Good morning. Let me just verify all the audio and video is recording on our end.
Okay, great. Good morning.
Good morning.
Morning. Terry and Krista. Krista, are you sitting in on any of these cases? Because on my script, it doesn't have Krista Long on here. It just has it ends at John Floyd.
I RSVP'd for the whole day, so I'm not sure what.
Okay.
I would defer to Terry. I don't know. Well,
Yeah.
Give me 1 second. Let me take a look at it.
Yeah, good morning. This is Shad. Just so you know, I'm a little hoarse. I feel better than I sound, but anyway, it looks like everyone that's here will need to be sitting on the cases today. I think the only one we didn't hear from was Raghu. I don't see him on here. So we have 5 members present.
Okay.
Now, and this is something, Douglas, if you want to make a determination on this, I know we spoke with Mr. Floyd earlier, and I'm not really sure how long he will be with us. He might have to leave, but he can speak to that. But
Mhm.
I'm not sure if you want to put the appeal first, since it was continued from the last meeting, or if you want to leave it where it is. So that's something that you can think about.
Yeah, I was considering that, given that the number of cases we have today, and I'm not sure how long those cases will take. Um,
Hey Douglas, this is Marshall Williamson. For what it's worth,
Yes.
I need to stop around noon for another appointment, so that plays into your scheduling.
Okay. Because we do have several items on the recommendation agenda, which we could probably do, well, it's up to the applicant, but, you know, potentially could be done with 4, which is a quorum. But if Marshall leaves, then that would take us down to 3, so that we wouldn't be able to continue afternoon.
Okay. Do we know? I'm sorry, Shad. I didn't mean to cut you off. My apologies.
That's okay. No, I was
Um,
just saying that was if Mr. Floyd doesn't leave, then that would still leave us with 4 people, board members at afternoon, but.
do we know if anybody is objecting the current cases we have?
Yes, sir. We have two separate cases that have opposition. I also emailed you the updated speech.
Okay. All right. So I would say that, and I'm not sure what the other board members feel about this, but I think that we should probably go ahead and put the appeals case first, given that was tabled to this meeting, and so that way it gives us enough quorum for now. And that way we don't have to worry about, we don't end up running the risk of tabling the appeals again until, you know, November, December of this year. But if anybody objects to that, please let me know before we start, if that's okay. Staff, are you okay with that, John?
I think that makes total sense.
Okay.
Me
And I'm
too.
sorry that I might have to bail. Terry knows what's going on. I think it's a legitimate issue.
Gotcha. Yeah, gotcha. Okay. So with that said, before I get started, staff, since this is the appeals is next, I just read my speech as normal and then say the next case is the appeals. Is anything special that I have to say in regards to that?
Douglas, do I
No.
need to look at anything since I wasn't here at the last meeting when you rejected this? Other than I read through the appeal, is that all I need to do to do this today?
Yes, ma'am. That's it. We didn't
Okay.
even get a chance to even open it last month. So
Okay,
yeah,
thank you.
you're welcome. Okay. Terry, is everything good on your end with audio and all that recording?
Yes, sir. We're recording on our end. We're good to go.
Okay. All right. Okay. All right. The October 26, 2021 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Douglas Wilson, Chairman. Also sitting on today's board is Deborah Dryden, John Floyd, Krista Long, and Marsha Williamson. Also present are Shad Spencer, our zoning administrator, Lisa McCarter, our planning project manager, Terry Hagler Gray, our senior assistant city attorney, Jill Sanchez Myers, our senior assistant city attorney, and our reporting is being done by Vertex Court Reporting. I would like to start by acknowledging that we are conducting this meeting using a remote electronic platform. This is the 16th remote meeting of the Charlotte Zoning Board of Adjustment, and I'd like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in Session Law 2020-3 that allows for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting will be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed consent to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicants and the public in several ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified the property owners of the remote electronic platform. And the letters also stated to contact the city immediately if there were any objections to the case being heard of today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notice for today's meeting contained information about means by which the public can access today's proceeding. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceeding. This information was also included on the board's website. Hearing, application for a variance from the regulation in the zoning ordinance. Application for a variance from the regulations in the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. Chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the agenda will be as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. Board may question the staff member and then the applicant may question the staff member. The applicant presents their testimony for this case. The board may question the applicant and the staff member may question the applicant as well. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak, pro or con, will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, yesterday, October 25th, in order to be considered at this hearing. If your case is not appealed to the Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board would not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appeal for another or otherwise assist or represent another at a quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform function to message the clerk. The documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of that case. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with the North Carolina General Statute 160A-388E as in Edward. In order to receive a written copy of this decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board clerk or chairperson at the time of the hearing of the case. As always, please remember to mute your microphone when you do not intend to speak. You will hear 8 cases today, 5 recommendation agenda items, 2 regular agenda items, and 1 appeal. The first case we'll be hearing today is the appeal. And Gustav, I will turn it back over to you.
All right, I would ask to be sworn in now.
Okay. Do you swear to tell the whole truth and nothing but the truth in the matter at hand?
I do.
I do.
Okay. All right, great.
All right, our first case is an appeal of the zoning administrator's interpretation that the subject property has common law vested rights from previous government approvals. And I'll give you a minute to look over your findings if you just let me know when you're ready for me to proceed.
Okay, Lisa, you can proceed.
Exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map. The zoning is I1CD, light industrial conditional zoning. Exhibit number 3 is an aerial map of the property. The aerial shows the General Commerce Center Industrial Subdivision where the subject property is located. The subdivision is comprised of several parcels of land rezoned from I1 light industrial and R9 single family to I1CD light industrial conditional district and I2CD general industrial conditional district by the Charlotte City Council per the rezoning petition 1990-073 on October 15th in 1990. This subdivision meets the definition of a planned development in the zoning ordinance because the development is outlined in a conditional plan. So if you can see my cursor, all this area is in the development. Exhibit 4 is a close-up aerial map. The applicant is Joseph Gatewood, who is appealing the zoning administrator's interpretation that the subject property has common law vested rights from previous government approvals. The applicant resides at 6123 Old Coach Road, which is the abutting residential property to the south of subject property. So if you can see where my cursor is right now. For Mecklenburg County tax records, Patricia Gatewood owns the home at 6123 Old Coach Road and has owned the home since 1988. The property owner of the subject property, which is located in the General Commerce Center development, is Frank Shepherdson. Government exhibit number 5. According to the zoning ordinance, since the subject property is in a conditional zoning district, it's subject to the specific standards and conditions of the 1990 approved conditional rezoning site plan. The development predates provisions for vesting in the zoning ordinance. However, it's subject to vested rights as provided in the state statutes, which are called statutory vested rights, as well as common law vested rights, which are authorized in case law. Our state statutes allow for a party with standing to challenge a determination made by the zoning administrator to the Zoning Board of Adjustment. Exhibit number 6 is a little more about common law vested rights. It is the zoning administrator's interpretation that the subject property has common law vested rights from previous government approvals. North Carolina courts recognize common law vested rights which run with the land and are transferred with the sale of a property. North Carolina courts use this test for the establishment of vested rights that's shown in the middle of the screen, and I'll go through them on the next slide. Exhibit number 7 is considerations for common law vested rights. The factors that are used to determine a vested right are a valid government approval, where the owner obtains an affirmative government action concerning a project. The expenditure made on a project must be in reasonable reliance on the valid government approval. The owner must
Excuse
make-
me, I'm sorry,
Yes.
Lisa, or Mr. Chair, can we, it looks like Ms. Dryden has disappeared and looks like
Oh,
she's having. I just
I'm
want to
here.
confirm
I'm
that
listening.
she is here before we continue to proceed. She's looks like she's having some connectivity issues.
No, I'm here and I've heard everything Lisa said.
Okay, perfect.
Oh, okay.
Thank you.
Okay.
All right. The owner must make some substantial expenditure, which can be time, effort, or money, in reliance of the valid government approval. The owner must act in good faith to obtain the vested right, having sought approval in the normal course of business and made expenditure to reasonably pursue the development. The owner must show that she will suffer harm or experience detriment if required to comply with the new rules. Exhibit number 8 is the rezoning petition number 1990-073. The General Commerce Center development, including the subject property, received valid government approval through the conditional rezoning approval and subdivision plat in 1990. So that's the valid government approval. Exhibit number 9 is the second page of the rezoning plan. Exhibit number 10, specific conditional buffer provisions. The applicant states that the subject property should be held to the current buffer standards and a 100-foot Class A buffer should be required. The approved 1990 conditional rezoning plan had a specific conditional buffer provision, and it is the zoning administrator's determination that the 30-foot wide undisturbed buffer and 7-foot tall wood fence shown on the conditional rezoning plan is the required buffer for the development of the property. This buffer width exceeded the minimum 20-foot buffer width required at the time of City Council approval. The subject property is 2.6 acres, and the total area of the General Commerce Center plan development is greater than 10 acres. If the General Commerce Center development was held to current zoning ordinance regulations, there'd be a required buffer width of 100 feet from abutting southern residential properties. But if the subject property isn't vested by common law into the approved conditional zoning plan, and the buffer requirements for the General Commerce Center development, then the parcel would be reviewed separately and only be required a 55-foot buffer width, which would be required for the 2.6 acre site. Exhibit number 11 is the subdivision plat approval. Exhibit number 12 is infrastructure expenditures. Infrastructure improvements have been made to the development in reliance of government approvals and in compliance with various regulations in place at the time of approval. Substantial expenditures have been made based on government approvals to construct public streets, install utilities within the planned development in which the subject property is located. The majority of properties within the General Commerce Center Industrial Park have been developed in good faith and reliant upon government approvals. Only 2 of the 19 lots within the development remain vacant. One of the 2 remaining lots is the subject property. Mecklenburg County has assessed the land and building values within the planned development at $16,012,000. Slide 14 is a buffer comparison. The property owner will experience detriment if required to comply with the new zoning buffer regulations. The developable width of the subject property is reduced from approximately 140 to 70 feet if it has to comply with the new regulations for the entire development. There would be 25 feet of additional buffer width required based on the acreage of the subject property if it were reviewed separately from the larger development and conditional zoning entitlements. Exhibit number 15 is determination factors of common law vested rights. The development, including the subject property, meets all the tests required for common law vesting. Exhibit 16, standards for granting an appeal. According to the standards for granting an appeal, the Board of Adjustment shall reverse or modify a determination upon finding an error in the application of the regulations. It's staff's recommendation that the Zoning Board of Adjustment upholds the zoning administrator's interpretation that the subject property has common law vested rights from previous government approvals, including the requirement of a 30-foot buffer and 7-foot wood fence along the southern property boundary, and the entitlements and conditions of the approved conditional rezoning petition for the General Commerce Center development. And that's the end of my presentation. The applicant also has a presentation, and the applicant is the neighboring property owner. And also the property owner, who is in opposition of the appeal, has a presentation as well. And they are both on the call.
Okay, thank you very much, Lisa. Does the board have any questions for staff? Okay. All right, hearing none. I believe that do we have the applicant on right now, Terry? And do we have any counsel with them?
That is correct, Mr. Joseph Gatewood. He is now a panelist.
All right. Okay. Good morning, Mr. Gatewood. How are you?
Good morning, Mr. Wilson.
Good, good. I will have to swear you in.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, great. And you're giving a presentation on your own. Am I correct?
That is correct.
Okay. All right,
Mr.
great.
Gatewood, I have the slides up for you, so just tell me when you want me to advance them.
Thank you. Thank you. All right. Okay, so I guess this is at the section where I ask questions to the zoning.
Mr. Gatewood, my apologies. We're having a hard time hearing you. It's like there's a slight echo on your end.
Okay, I think.
Still there.
Hello?
Yes, Mr. Gatewood, we're here.
Okay,
Okay, that's better.
all right. I think this is the point where I get the ask question to the presenter, to the board. I'm not the board, but the administrator.
This is where you would present your slides and your presentation. You know, if you have presentation, you're more than welcome to show it now. But as far as asking questions to staff, I will defer to Jill or Terry for advice on that.
I was just looking at the order of Board of Adjustment agenda item. That's what I was going by.
Okay. No, this is the part where you present your case, and then afterwards, you know, the board may have questions for you, and then I believe that you are able, and correct me if I'm wrong, city attorneys, but I believe you'll be able to ask questions to the zoning board staff.
Okay, all right. Well, I'm ready to
Mr.
proceed.
Chair,
So,
if I
Yes,
may
ma'am. Yes.
weigh in. Yeah, per the rules of procedure, after the city staff presents their evidence, the board and the applicant do have the opportunity to cross-examine or to, ask any questions of the city staff or their witnesses. And I believe that would include the zoning administrator. And then the board can move on to the applicant's presentation, and then staff
Okay.
would be able to ask questions of him as well.
Okay, so Mr. Gatewood can ask questions to the staff right now. Okay, all right. Okay, Mr. Gatewood, my apologies. You can ask your question.
All right, I have some questions for the staff. Now, in the presentation, we talked about common law vested rights. But in my reading of North Carolina General Statute 160D-108, the vested rights that they are referring to are the vested rights of the owner. And if you would notice in the presentation, it always talked about owner and, of course, not the expenditures of anybody else. So my question to staff is, when did this owner take title to the property at 1700 Industrial Center Drive? This owner.
I think you're asking if the current property owner who purchased it, I think this past year, if they have the rights to the common law vested right. And they do. The vested right is transferred when it is sold. It's based on the overall development.
Okay, but my question is, when did this owner purchase the property?
The owner of the property is also in the meeting, and his attorney, and I may let them address that question, and they may address it later on in their presentation.
Okay,
Mr. Chairman, David Murray here. I represent the owner, which is a corporation, Washburn 3100 Incorporated. Frank Shepherdson is the representative, but Frank purchased this property on my birthday, April 15th, 2021. So my client has been the owner since April 15th of this year.
Okay.
So this owner just took possession of the property April the 15th of 20. I think the tax record showed whether yes, it closed on April 15th, 2021. So what zoning ordinance were in effect and this owner purchased the property? Because what we are talking about is the vested rights of the owner of the property. So what zoning ordinance was in effect when this property owner purchased the property?
And I think that's the purpose of your appeal, is that we are saying that based on the fact that this planned development has common law vested right, that the zoning ordinance in place at the time it was approved for conditional rezoning would apply, since that conditional rezoning had a specific buffer standard that applied to this subject property.
Excuse me, who's answering the question?
That was Chad Spencer.
Okay, all right. I didn't see him on the screen, so I wasn't sure. So the question here, I'm trying to get a straight answer. Does this owner have a vested right? Because that's what this is about, to establish the vested right of this owner. Hello?
Is that a question? I mean, that's
Yes,
the
that's the
purpose
question.
of
That's the question. The question is, when did this owner get a vested right?
The owner is entitled to the vested right that applies to this plan development. Yes,
And that's according to statute.
that is the common law vested right.
Okay, so we're talking about common law vested right, of course. Now, when you talk about common law vested rights, of course, there are several criteria in order to establish a vested right. And of course, that is the requirement that is placed on the owner according to the statute. So what substantial expenditures has this owner made prior to January 1992, when this new ordinance went into effect? This owner.
No, this is David Murray. This is a quasi judicial hearing, so I do have to object to the record. I would just object that this line of questioning is immaterial on this issue, as vested rights run with the land.
Excuse me. These questions are for the zoning staff. These questions are for the zoning staff according to the procedures.
And I'll interject here real quick just to make sure we have fluidity here. Jill or Terry, I believe that Mr. Murray is correct, since we are quasi-judicial body, that he can object or he cannot. I just want to make sure that we're all on the same page here.
Yes, so Mr. Murray's client is also a party to this hearing because his client is the property owner. So he is, they are a party to the appeal, just as the applicant. So any party has a right to object. So that's correct. He can object at any time. And you can just note it for the record as well.
Okay, just note that for the record then.
So what we're saying is that the current owner, whether the current owner has a vested right or not, is immaterial. Is that what we're saying?
Mr. Gay, sorry, I just want to make sure he was asking the question to staff. Wasn't sure if he was responding to Mr. Murray.
The question I'm asking is, so are we saying that the current vested right is immaterial, whether the current owner has a vested right or not?
Yes, I mean, that's the determination has been made that the current property owner has the rights for the development, which has common law vested right. So it's entitled to that.
So where did this current owner, so if you got a vested right, where was it transferred from? What landowner was the vested right transferred from?
From the previous owner and the person who ultimately originally developed the site.
Okay, now according to common law vested rights, it says, so are you referring to the development agreement?
I guess I need to know what you refer to as the development agreement.
Well, the development agreement is one of the paths where an owner can establish a vested right. So is there so you're referring to, I assume you're referring to the General Commerce Center. It's where this vested right came from. So my question is was the vested right transferred per the development agreement?
The original developer obtained valid governmental approvals back in 1990. And then that original developer relied on those approvals to make infrastructure improvements and made substantial expenditures to develop the site. So they acted in good faith on that original approval, governmental approval. And therefore, the site, the planned development, has common law vested right. And so that common law vested right is transferred to the current property owner, because if the current standards of the ordinance would be imposed on this property, the property owner would experience detriment because it would drastically reduce the developability of the site.
Go back to my original question, is that part of the development agreement? Because in North Carolina, there are 4 plans for an owner to establish a vested right through common law. And one of those is to have a development agreement.
It's
So
the
is that part of the
site-specific
development agreement?
conditional rezoning plan that, I guess what you're referring to is the development agreement. And that site-specific conditional rezoning plan was approved by City Council in 1990.
Okay, so if it was a development agreement plan, so it was there was a development agreement. Was there or was there not?
It was a conditional rezoning plan. I'm not sure the terms that you're using. No, it was not a development agreement. It was a conditional rezoning plan. It was a site-specific conditional plan for this plan development that was approved by the government. So the original developer acted in good faith on those governmental approvals in order after that to make substantial expenditures to develop the property.
Now, in my reading the statute owner refers to expenditures by owner. So I'm not getting where you are going back to what we're talking about is a vested right. That's what the issue here is, a vested right, whether this owner has a vested right or not. And I'm not getting a clear answer on that.
So maybe the thing is there are 2 types of vested rights. There are statutory vested rights, which are time periods that are assigned to certain approvals. And so the validity of those approvals are valid for only a certain amount of time. And if it's not developed, then it could potentially lose that statutory vested right. But then there's also common law vested right. So then if the approval was granted by the government and the developer acts in good faith on those approvals and makes substantial expenditures, then that plan development receives common law vested right. Those are the 2 types of vested right. And based on 160D of the North Carolina State Statute, it gives the zoning administrator for the jurisdiction that the property is within to make that determination of vested right. And therefore, that's why we're here today, because I made the determination that based on, again, previous governmental approvals, the development of the site based on those governmental approvals, substantial expenditures, and that imposing the current standards would be a detriment to the property and the property owner, that it qualifies as common law vested right. And that vested right was transferred from the original developer to the owner after that, to the owner after that, and to the current owner. It goes with the land.
Okay, so what specific paragraph in the North Carolina General Statute that you are referring to that gives this owner a vested right? Of the North Carolina General Statute 160D-108 covers several pages. So can you point to the specific item in section North Carolina General Statute 160D or 108.1 that gives this owner vested right? Can you point to that specific statute item? Because now we're talking about statutory vested rights.
Well, the focus of this case is common law vested right, not statutory vested right.
Okay, well, okay, so when we go back to common law, so if you go by common law, you're talking about the expenditures of the owner. Which also says statutory vested right. So we're in the statute, the specific line in the statute that gives this owner a vested right in the North Carolina General Statute.
Can you pull up this page on the screen that talks about the factors? There we go. Can you see there on the screen? These are the factors that's been determined by North Carolina courts as being factors for common law vested right. On government exhibit number 15.
Okay, but everything I see, it says the owner, an owner. You talk about common law vested rights.
But the common law vested right transfers.
Okay, so when did it transfer? And who did it transfer from?
To the current property owner.
Pardon me?
To the current property owner.
But who specifically did it transfer from?
I don't know who the previous property owner was. You may have to, maybe the applicant, I mean, the
So you
current
don't,
property
okay,
owner.
so you made a determination, you don't
attorney.
know who the previous property owner was. Is that what you're telling us?
I'm sorry, but was that I'm not sure what
You
you're asking.
made a determination saying that the vested right was transferred, but you don't know who the previous property owner was. The
That is
transfer of
correct.
the vested right. That's my question.
The answer is I do not know who the previous property
Okay,
owner
if you don't
was.
know, that's fine. We can move on from that. We can move on from that. If you don't know, you don't. Okay. Now you say that imposing the buffer provisions in the current owners would create a detriment to the subject property. Create a detriment. Imposing. So you're saying the ordinance is an imposition on the property owner. Can you expand on that, please?
Yes, if you look at government exhibit number 14, which is shown on the screen right now, at the top of the page, you can see the current standards that are applied to the subject property per the 1990 governmental approval, which was the conditional rezoning plan approved by City Council. It indicates a 30-foot undisturbed buffer along the property line with a fence. And the approximate developable area is about 140 feet of width. Then if you look at the lower part of the screen here on government exhibit number 14, this is what you are indicating that you believe is the appropriate buffer requirement, which is in today's zoning ordinance, which is a 100-foot Class A buffer. So with that 100 feet, that reduces that developability of that site from 140 feet by half down to 70 feet. So based off of that, that would mean that the property owner would experience detriment if required to comply with the new zoning buffer regulations.
Okay. So you're saying that if the current zoning ordinance were applied, the property owner would lose or develop a portion of his property. That's what you're saying.
That is correct.
Okay. So I go back to my original question. So this owner did not purchase this property for April 15 of 2021. So he should have known that when he bought the property. Is that correct?
Objection is speculation.
Speculation. He bought the property on April 15, 2021. That's not speculation.
Calls for speculation as to what he was thinking. We'll have a presentation. We'll go through that. Thank you.
Okay, all right. We'll move on. We'll move on from that. Now you're talking about the detriment that would you talk about the detriment that would create this owner that purchased this property on April the 15th, 2021, after the current zoning ordinance was already in place. Current zoning ordinance was already in place when he purchased this property. And you're talking about it would create a detriment to him. So my question is that at any point did you consider the detriment that would cause to the 260 properties in the abutting subdivision if the 100-foot buffer was not put in place?
That is not part of the evaluation for common law vested right.
So in other words, we're talking about your determination now. So when you made the determination, you did not consider the effect on the 260 residential properties, R4 zone, with a less intrusive intensity, and in favor of a more intrusive zoning, an I1 industrial zone. So my question is, did you ever take in consideration the residents in the neighborhood, in Bridlewood community? Did you ever take into consideration the detriment to their property?
What I considered was the conditional rezoning plan that was approved by City Council back in 1990, which was then developed by the developer / property owner at that time in good faith on those government approvals granted by City Council back in 1990. And therefore, going through, like I've mentioned earlier, all those common law vested right factors, it met all those common law vested right factors, and therefore that's the determination that the planned development has common law vested right, and therefore any subsequent property owners have that common law vested right.
Okay. So you base your determination based on the common law vested right, but you don't know who transferred the vested right to the current law. Okay. Now you mentioned it has been established in case law. You mentioned that it had been established also in case law. So what specific case are you referring to?
I'll probably defer at this point to the property owner of the subject property and their attorney to discuss case law, since there is an attorney involved in that on that side.
Well, I'm asking you about your determination. How you made your determination?
I've indicated to you.
Pardon me?
Yeah, Mr. Gatewood, I've indicated multiple times as to how I made that determination.
But you said it was based on case law. But I do know that you cannot use case law as an argument if you can't cite a specific case. But we're talking about the determination. How you came to this determination. You cite case law, but you don't give us a case.
I'll jump in a little bit at this point. Mr. Gatewood, the common law vested rights case law authority comes from a number of cases over the years where determinations have been made about what constitutes a common law vested right. And that is where the criteria that the zoning administrator used came from. It's a combination. You may not be able to point to one specific case. If you'd like one specific case, I can go to Westlaw now and get you a case. But it's a combination of cases over the years.
Well, but what we're trying to get to is the zoning administration made a determination. Now, if somebody can go find a case law, I mean, that's fine, but what we're looking at is the information that we received. That's what our appeal is based on. information that we received to make an appeal. And
Yes,
we
sir.
did not receive a case law to substantiate the determination. And that's what I'm asking.
Okay, so, I would just say, for the record, there are two types of vesting. There are two types of ways that a property can become vested. And that invested means it has the right to build the way it was approved by the government. One is statutory, which means a building permit was obtained, and for a certain amount of time, there's an ability to develop the property under that permission, an application, a building permit that was obtained by the government. And another way, when there isn't that type of building permit, is 160D has now given the zoning administrator authority to look at the overall picture, and that is called common law vested rights. And when we say it's based on case law, it is case law over the years that has determined those criteria that the zoning administrator has laid out for you. So, the criteria that have been laid out, that is what North Carolina law has determined is what you would use as a zoning administrator to determine if common law vested rights are available.
Okay. Okay, but basically, I was. Thank you for that clarification. I've read up on common law vested rights as well as statutory vested rights, and of course, but my questions are based on the determination letter that I received. And in the determination letter I received, if you would like to go to exhibit A. In my exhibits. And of course, if you would notice in that determination letter, there's no reference to any code or exhibit number A. There's no reference to any code in that determination letter. It speaks generally about statutory rights, and it speaks generally about common law rights with no specifics. And it talks about case law without providing us with a case. And that is what my line of questioning is based on. So my line of questioning is trying to determine how the zoning administration made the determination. Because we have not received.
Mr.
Gatewood, Mr. Gatewood, I just and I'll go find a case for you, but I'd like to kind of reset things because the zoning administrator has indeed made a determination, and you disagree with his determination. And so as the applicant, if you disagree with his determination, you have to show that he was in error in making it. So are you disagreeing that the common law vested right criteria that we set out for you are incorrect, or are you disagreeing that challenging the zoning administrator's application of that criteria to this particular property?
Yes, I am appealing his determination based on the North Carolina General Statute and Code Section 1.110. What I've read in the code and what I've read in the North Carolina General Statute.
Okay, so do you disagree that those are the criteria for determining what common law vested rights are?
No, I do not disagree with that. What I disagree with is the assertion that this owner has a vested right.
Yes, sir.
And of course, according to what I read in the North Carolina General Statute, and that's why I keep referring back to development agreement. And of course, the development agreement will specify what rights are transferable, when they are transferable, and all that would be in the development agreement. Of course, North Carolina General Statute, that should be a development agreement, it should be recorded with the Register of Deeds.
No, sir, that's not the only way that a property owner can get can get vested rights. A development agreement is one way, but as the zoning administrator has testified today, a site-specific development plan, conditional rezoning will also give an owner vested rights.
And like I
And I
said,
think
the
that's
key
what-
word is owner. But like I said, we don't have anything in the record to see where these vested rights that were transferred to this owner came from.
Okay.
Members of the board, this is David Murray again. The owner has a presentation that will be made in this case. And just so we're clear, in discussing how to proceed, there was an agreement with the owner, Ms. McCarter and Mr. Spencer, that we would talk about the specifics of our owner as part of our presentation. And so the zoning administrator has given his part of the presentation. We still have ours to give. What I'm trying to be clear on here is Mr. Gatewood giving his presentation, or is he still asking questions? Because at this point, he's supposed to be given his presentation. And it seems like we keep going back and forth on whether we're talking about statutory versus vested rights. I don't think anybody here is arguing statutory vested rights. We're only arguing common law vested rights, just so we're clear.
Mr. Gatewood, I was going to interject and ask you if you had a presentation to give, or are you still in the process of asking questions?
Okay, well, I'll go ahead and make my presentation. Of course, by now everybody knows I'm Joseph Gatewood, and I'm the applicant here. I'm here with my wife, Patricia Gatewood. We live at 6123 Old Coach Road in the Bridlewood community. Our property abuts the rezone district that zoned a residential zone to a light industrial zone in 1990. Included in that district is 1700 Industrial Center Circle, tax parcel 097 223-05, which is the property in question. We are not here to ask for a variance or change the ordinance nor the statute. We are not here to stop the owner from using his property. Our case is based on the zoning ordinance of Charlotte, North Carolina, North Carolina General Statute 160D-108, vested rights, and is rooted in the 14th Amendment of the Constitution of the United States of America, the equal protection of the laws. And of course, an ordinance is a law. We are asking for the equal protection that's afforded to us by the 14th Amendment. The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. Those are the words of John Marshall, who delivered the majority opinion in the landmark case of Marbury versus 90 in 1803, that established the principle of judicial review and established that the Constitution of the United States is not just a collection of ideas and principles, but it's the supreme law of the land. Equal protection of the law is what we're asking for. The procedures for establishing a vested right pursuant to North Carolina General Statute 160D-108 1.1 refers to the landowner at least 9 times. The determination letter we received from the zoning administrator does not refer to the landowner once. Zoning administrator's finding the fact presented to this hearing carefully evades the owner's responsibility in establishing a vested right according to Code Section 1.110 and North Carolina General Statute 160D-108, but instead talks about the vested rights of property and the vested rights of the general commerce itself. The word property is a common noun that denotes ownership by some person or entity. The owner of this property is not a mystery. Property cannot apply for a building permit. Property cannot have expenditures, nor can a property hire an attorney. The only vested right that a property has that must be established are the vested right of the owner. To this date, this owner has not established a vested right, and there are no assignable vested rights in accordance with the procedures set forth in Code Section 1.110 pursuant to North Carolina General Statute 160D-108.1. In North Carolina, there are 4 paths for an owner to establish a vested right. Common law vested right, and of course, the common law vested right is reasonable time. Reasonable time. If a common law vested right had been established 31 years ago when the property was rezoned, that would not be considered a reasonable time, 31 years ago. And it also considers whether the owner has a valid building permit. Valid building permit is valid for 6 months. And to this date, no this owner and no other owner has had a building permit issued. Property has been undeveloped, as far as I know, since God created this earth. And then, of course, it talks about a development agreement. Development agreement. A development agreement is good for up to 20 years. And a development agreement has to be notified by the public, and there must be a legislative hearing. And in no case can a development agreement be over 20 years. So my question was, where is the development agreement for this property? And of course, once the development agreement expires, it can be renewed with a legislative hearing and public notice per North Carolina General Statute 160D-1004. Because the specific development plan or phase development plan, if it is that, it's 2 to 5 years. Now, the key word is owner. And these paths must be established by the owner before the zoning ordinance changes, not after. The area where the property in question is located was changed from an R4 zone to a I1C zone in October 1990. Incidentally, just 15 months before the current zoning ordinance took effect January of 1992. Current owner took title to this property April the 15th, 2021. And until recently, the parcel of land did not even have as much as an address. Didn't have an address until recently. I think they got one around July or something. Since the current owner has not performed the procedure set forth above to establish a vested right before the ordinance changed, any construction at 1700 Industrial Center must be in accordance with the buffer requirements in Code Section 12.302, which is a Class A buffer with a 100-foot width, which would better serve the purpose of the code as stated in Code Section 1.102, which reads in part, these regulations have been designed to promote the public health, safety, and welfare. Zoning administrator has not provided any case law to support his determination. And the determination is not supported by North Carolina General Statute 160D-108.1, nor the North Carolina zoning ordinance. Therefore, the determination is arbitrary, capricious, and discriminatory. The zoning administrator shows no deference to the concerns of the homeowners affected by the determination, but has put a lot of effort to find credence for the owner to build an industrial building 30 feet from our home, which would not serve the purpose of the ordinance. I don't believe anyone in this room, anyone under the sound of my voice, including the owner of 1700 Industrial Center, would want an industrial building 30 feet from their home. And the zoning changed for a reason. It changed for a reason. In the hierarchy of zones, in Charlotte, North Carolina ordinance, the R4 zone is at the top, and the I1C zone is at the bottom in the hierarchy of zones in Charlotte, Mecklenburg. The R4 zone is at the top, the I1C zone is at the bottom. Now, if there is any ambiguity in the ordinance, in the North Carolina General Statute, and I don't believe there is any ambiguity, I think it's clear. It seems that the zoning administration would at least give priority to the R4 zone, as the ordinance does consider the purpose of the zone in Code 1.102, which reads in part, these zoning regulations have been designed to promote public health, safety, and welfare. I am 100% sure that these ordinances were not enacted to let real estate investors, business speculators, and property developers profit at the expense of public health, safety, and welfare in the environment. I don't believe that's the reason these ordinances were put in effect. Now, consider these facts. Consider these points. The code changed for a reason. Why did the code change? Well, Charlotte has changed. Charlotte has changed over the last 30 years. You got more people in Charlotte. The land is becoming more congested. So the code had to change to accommodate for that. Look at that, the economic impact on the neighborhood. Let's say, for example, the valuation of residential property. I put an industrial facility 30 feet to the neighborhood.
Valid government approval.
I mean, the residential properties, there are 260 homes in that neighborhood. It's a very modest neighborhood. Those homes are valued on an average about $235,000. Look at because when you're talking about a neighborhood residential, you're looking at, say for example, if my home is depreciating in value, that's going to depreciate everybody else's home in that neighborhood, because when you're trying to determine the value of property, it's based on the comparable properties that have already sold. If you look at the exhibit that I put up, it talks about that in the
authority and purpose of the code is not being fulfilled.
Just reminded everybody, make sure you have your lines muted. I hear some background noise during Mr. Gatewood's presentation.
Okay. So placing a non-residential property that's close to residential property will cause a depreciation of the home value, because it's in the disclosure statement. Is there a non-residential building in close proximity to the property that's being sold? And of course, that will result in a loss of tax revenue. Because the value of the homes go down, it's a loss of a tax revenue for the city of Charlotte. And then once the neighborhood, because an industrial complex is built in 30 feet of our home, and because of the depreciation of the other home, then of course it makes it hard for these houses to sell. And then of course, the neighborhood becomes a haven for slumlords. Also, insurance companies are asking the question: is there a non-industrial building within 300 feet of the home? Because quite frankly, I don't think 100 feet is enough. I don't think 100 feet is enough. And insurance companies are asking if there's a 300 non-residential building close to the property. Insurance companies are generally proactive in identifying hazards that might result in a loss. And having a industrial building within 30 feet of a residential property is definitely potential for a loss. Since the current owner has not established a vested right, and according to Code Section 1.110, pursuant to North Carolina General Statute 160D-108.1, any new construction at 1700 Industrial Center Circle is subject to the buffer requirements in Code Section 12.302. The Class A buffer with a 100-foot width as stated in the 1992 Mecklenburg Ordinance codified through June 15, 2021, which will better serve the purpose of Code 1.102, which reads in part: these zoning regulations have been designed to promote the public health, safety, and welfare. Thank you.
Thank you, Mr. Gatewood. Does this conclude your presentation?
This concludes my presentation. Of course, according to the agenda, I think I will have some rebuttals and closing remarks. But my wife, she has the presentation.
Okay. I will have to swear your wife in as well. But
Okay,
before
no,
I do that, board members, do you have any questions for Mr. Gatewood before I go to the rebuttals from Mr. Murray? Okay. Hearing none, Mr. Murray, do you want to do your rebuttal right now?
I'm sorry, Mr. Wilson. I was on,
Yes.
I couldn't get off mute. I'm sorry.
Okay.
Just wanted to, on behalf of staff, just before we go to Mr. Murray's presentation, just point out some things. I wondered if staff could pull up 160D-108 for the Board of Adjustment.
Yeah, we're working on that. We're going to try to put that in the presentation and put it up on the screen.
Mr. Gatewood, also, I do have a site for you. Walton, Carolina LLC versus the City of Concord, 809 Southeast 2nd, 164, 257 North Carolina, Appellate Court 227. It's a 2017 case that sets out the elements for establishing a common law vested right as being a substantial expenditure in good faith reliance on a valid governmental approval resulting in the party's detriment.
All right, we have 160D up on the screen. 160DI is the one I think you're referencing.
Yeah, right. I just wanted to point out, well, first of all, I wanted to point out that Mr. Gatewood keeps referencing a development agreement, which is a way to obtain a vested right. But if you look at section C under vested rights, C3, a site-specific vesting plan pursuant to 160D 108.1, I believe is what is applicable here. And also, if you go to I.
Excuse me, may I interrupt?
If you could just let me finish, and then.
I just had a question because I didn't hear what you said.
Oh, I'm okay. I'm sorry.
I didn't hear what you what do you say was specific here? Which procedure? What is this site?
160D-108 C under vested rights.
Mm-hmm.
If you look at 3, that talks about site specific. Yes, and so our conditional zoning plans are considered site specific vesting plans, and that's what's at issue here.
Okay, so if that's the case, may I interject since she brought that in?
Yeah, let me just say one more thing, and then let me just say one more thing, just addressing. I just wanted, and I'll just do it in the form of a question, since you are the applicant and you're making a case, and it's your burden to show that the zoning administrator erred in the application of the ordinance. I'd just like to ask you if you are aware of section 160D-108I, and I'd ask the staff to put that up under miscellaneous provisions. This shows that the vested rights granted by this section run with the land, except for the use of land for outdoor advertising, and that's specific to billboards. And so running with the land means that a new owner can claim the right by a previous owner. The rights, basically, what run with the land means is they transfer.
Okay. Okay, she said that a site-specific plan is what, well, of course, by definition, this is type of element of the plan approved in 1990. I agree with that. A site-specific development plan or a phase development plan, the vested rights run from 2 to 5 years. So if there was a vested right by that the previous owner got, it would have expired by now. Because a specific development plan or a phase development plan, the vested right is from 2 to 5 years. And by definition, that's the type of development plan that we were referring to, that vested right has expired.
Yes, sir, you're correct that statutorily you can get a minimum of 2 years and a maximum of 5 years of vested rights for a site-specific development plan. If substantial expenditures have been underway and development of the site begins before the end of that period, that is when the vested rights attach.
But as you pointed out, the site-specific plan and any vested right for a site-specific plan is good for 2 to 5 years.
It's good for a minimum of that. If the development gets underway, begins construction during that period, then that's when the vested rights attach, and you can rely on those vested rights until you complete the plan.
And Terry, just so I'm clear, this is David Murray. Just so I'm clear, we're talking about common law vested rights taking over, correct?
Yes, sir.
And also, Mr. Spencer has his authority under subsection H to make a determination on common law vested rights.
That's correct.
I feel like I'm not cross-examining you right now. I'm just.
That's okay. No, but I think that 160D 108, which is a relatively new section for everyone, It's also, you know, it's been kind of an open issue of, you know, who has the determination, who has the right to make a determination about common law vested rights. And when 160D was passed and went into effect last year, it gave the zoning administrator the authority to make the common law vested right determination. Obviously, the statutory vested right determination is easy. You can point to when a building permit was issued. The common law is a little bit more difficult to ascertain, but in this case, we have a real pretty old development plan that I believe Mr. Spencer is pretty well built out. Is that true?
Yes, that's correct.
Okay, that's all I have.
Okay, thank you. And have I been pronouncing your name wrong, Terry?
Well, I think it's because we have a Terry now, but it's Terry. Yes.
Terry. Okay, my apologies.
Sometimes you do it right, Douglas, and sometimes I think you are thinking about Terry, our new clerk.
Okay, my apologies. Okay, all right.
No
Just want to make sure.
Yeah.
Okay. Okay.
Mr.
Murray.
Chairman,
Yes.
Mr. Chairman, just real fast on, because again, we're quasi judicial, I have to object on the record. For Mr. Gatewood's testimony, I do have to object on speculation grounds on his testimony about values, tax values, impact on adjacent properties, speculation on the intent of city council and the ordinance, and then again, immateriality of statutory vested right discussion, since we're talking about common law vested rights here. Thank you.
Okay.
May I address that objection, please? May I address that objection?
Yes.
Now he said
Yes.
that the speculation. I would like to inform Mr. Murray that I am a real estate broker, licensed in the state of North Carolina. Matter of fact, I'm a broker in charge, real estate broker. So I can speak on the value of property. I am qualified to speak on the value of property.
Okay, thank you. All right. Does any staff members or board members have any questions for Mr. Gatewood before we go to rebuttal to Mr. Murray?
Well, actually, my wife, she hadn't made her presentation yet.
Yes, we're definitely going to get your wife's presentation, but I believe the process requires a rebuttal from Mr. Murray, and city attorneys, correct me if I am not correct.
Ms. Gatewood can go ahead and go if she'd like.
Okay, yeah, I was just gonna note
Okay.
that Mr. Murray has the opportunity to question or cross-examine Mr. Gatewood, but if he is fine going
Okay.
to Ms. Gatewood, that's fine.
My only question for
Okay.
Mr. Gatewood is just to confirm that in 2003, Mr. Gatewood, you took your name off the property as an owner, so you are not a deeded owner of this property that you live at, correct?
I am a deeded owner of the property and I have marital rights. And the reason I took my name off the property because I was diagnosed with cancer and I thought I was going to die. So I deeded the property over to my wife.
Okay.
And then, of course,
Okay, thank you.
and then I added my name back to the deed. But I do have marital rights.
Okay, thank you.
Thank you very much. Okay, Mr. Gatewood, is your wife on so I can swear her in?
Yes,
Okay, could you please state your first and last name?
Trisha Gatewood.
Okay, good morning, Mrs. Gatewood. Do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, and before you present, I just want to remind you to, if possible, please try not to repeat any of the presentation that was given by Mr. Gatewood or any arguments that was presented earlier. And if there's any new information, please present that.
Okay, I just have a statement. My name is Patricia Gatewood. I live at 6123 Old Coach Road in the Briarwood community. I have lived there for 33 years. The parcel of land in question was purchased by the current owner on April 9th, 2021. On my birthday celebration, April the 24th, some clearing of the land was taking place. My guests and I were stunned at how close the cleaning of the land was taking place to our property line. At the time, I did not know the zoning ordinance required a Class A with 100 feet width. However, I knew what they were doing didn't look right to me. Since some of the trees have been removed, I can see another industrial structure from our family room, which does not make me feel comfortable at all. We can see the loading dock with the trucks coming in and out and the parking lot filled with various vehicles. Virtually all the wildlife that had taken the area for a sanctuary have gone. We no longer hear the chirping of birds, but now the clacking noise coming from the industrial buildings that is nearly 300 feet from our property. A 100 feet buffer is not adequate to us, but it is my understanding that's all the law requires. The thought that the city would allow a warehouse to be squashed in a small area between our backyard and the other industrial building with no regard to the environment, our health, safety, peace, and quiet is unconscionable. I retired from healthcare after 43 years of service and was looking forward to beautifying my backyard with my flower gardens. That's what I have been doing since I retired in 2016. I was very disturbed when Joseph, my husband, told me the current owner of the land that had laid vacant since I moved there 33 years ago was planning to build a warehouse made of metal 30 feet from my flower gardens. We knew we could not stop him from using his land, but we also knew that current zoning ordinance would mitigate the devastation caused by building a warehouse 30 feet from our backyard where I like to work in my flower garden and our grandchildren like to play. Our neighborhood does not have $1 million homes, nor a tree reserve like the neighborhood where the owner of the property in question lives. Nevertheless, we value our neighborhood because that's where we live. We deserve and demand the same level of respect and protection of the law as any neighborhood in Charlotte. And that's why we're here today. Thank you.
Thank you, Mrs. Gatewood. Does any board members or staff have questions for Mrs. Gatewood? Okay. Mr. Murray, do you have any rebuttal for Mrs. Gatewood?
Just one question. Ms. Gatewood, when did you purchase the property? I think you said 33 years ago. Is that like 1988 or 89?
Around, yes, that's correct.
Okay. Thank you.
Okay. Thank you very much, Mr. Murray. I believe that concludes the presentation from the Gatewoods. Now we will move to the presentation from Mr. Murray and the property owner.
Thank you, Mr. Chair. My client.
And my apologies, Mr. Murray. I just wanted for formality to swear you in.
Sure, and also we need to swear in Frank Shepard. He's on the attendee list.
Okay.
If we can make him a panelist.
Okay. So Mr. Murray, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay. And your client's name?
Frank Shepardson is my client.
Okay. Mr. Shepardson, I'm not sure if you can hear me.
I can.
Good morning. Good morning.
Good morning, Mr. Wilson.
Okay. Thank you. Frank Shepardson, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, great. Okay, Mr. Murray, you may proceed.
Thank you, Mr. Chair. Frank, I'm just going to go with Frank. Frank, did you retain me to present and testify on your behalf at this hearing?
Yes, sir.
And you've reviewed the PowerPoint presentation as well as the city's presentation, and they are accurate to your knowledge?
Yes, they are. I have reviewed and they are.
All right, thank you. Lisa, are you the one controlling the PowerPoint?
Yes.
Okay, thank you. Can you go forward, please? This is our Exhibit 1. Again, a lot of this stuff, I appreciate Shad and Lisa's presentation. Again, my name's David Murray. I'm an attorney with the Odom firm. I represent the property owner here. We adopt the city's portion of the presentation as part of our own. Again, the property that we're focused on here is Lot A on this approved plan from 1990. There was an administrative approval in 1992. I believe some other administrative approvals thereafter. The red arrow shows the lot. It kind of looks like a shoe and very unique lot shape. Next slide, please. This is enlarged view. The 30-foot buffer that's shown here on this lot is actually more than was required at the time, and is also more than, as you will see, is on other adjacent properties in this development that backed up to residential. Next slide, please. This is Exhibit 2. Thank you. Next slide. Mr. and Ms. Gatewood have testified already. This is our view of the appeal, alleging that the 30-foot undisturbed buffer is no longer in effect. They want a 100-foot buffer. The issue with that, though, is to presume that a 100-foot buffer applies to this property, you must also presume that it's still part of the larger tract. So to be part of the larger tract and larger development, it would still comply with the development plan. So there's, the argument is a bit inconsistent here that the appellant is making, the modern buffers that they would be seeking to have applied to this property are a lot different than an undisturbed buffer. So a 30-foot undisturbed buffer means that the trees that are in place are not disturbed. There's never been any allegation, never been any notice of violation from the city, never been any allegation by the city that anything that my client has done on this property has been improper in any way. The city has agreed with what my client has done the whole time. Also, and I think this is important and needs to be pointed out, that if a modern buffer applies to this property, it allows this owner to actually clear that whole area, to clear all the trees up to the property line, install a berm, and then replant approximately a 41.25 foot buffer. So the undisturbed buffer, if this board does not rule to affirm that buffer under common law vested rights, then essentially this board is ruling that my client can go in and clear that buffer, establish a berm, and then plant a new buffer, which will not provide the type of privacy that even this current buffer allows. So I think that's very important to understand here. Next slide, please. This is an aerial, Exhibit 3. This is an aerial of the Gatewood property. You can see there's a red box on top of it. And the property immediately to the rear is my client's property. You can see it has trees on it. Next slide. To summarize the interpretation by the zoning administrator, common law vested rights exist. 30-foot buffer is what was required under the plan. This development was rezoned as part of a larger industrial project. City council determined what conditions were reasonable at the time of this adoption. This was a city council determination. And this appeal is essentially asking this board to overturn a city council determination for this rezoning. As you could see on that site plan, the houses, including the house where the Gatewoods live, and I believe Miss Gatewood did live there at the time of this rezoning, that those were, that those lots, those residential lots were in existence with houses built upon them at the time that this rezoning was approved. Next slide, please. So the present situation, and I believe Ms. Hagler-Gray and Mr. Spencer have gone through this pretty thoroughly, is that some of these 160D statutes are new. So there haven't been a lot of cases interpreting it. And in general, it doesn't appear that there's a lot of cases dealing with this situation where the government has made an interpretation that there are vested rights and an adjacent owner has appealed. In most of the cases that you find that talk about these situations are where the owner of the property is trying to assert a vested right against the government and is having to prove that they have a vested right against the government. And the government is pushing back saying, no, you don't have a vested right. And that's not what we have here. What we have is the property owner and the city agree that there's a vested right. And so there's not, and I have not been able to find a specific case on point where an adjacent owner has challenged that determination. And can we go to the next slide? And there's a reason, I think, why there appears to be a lack of cases on that specific issue, because of why there are common law vested rights in the first place. The vested rights determination, in summary, is a balancing of the rights between the government's interest in zoning and the property owner's interest in having due process, equal protection, and right to develop their property. And so the common law vested rights idea was found in case law to balance those two. So when a property owner is seeking to develop property and they want to do a certain type of use, and then the government turns around and says, oh, we don't want that use to happen, we're going to change our zoning ordinance, there are certain situations where the landowner is still protected. That is a very common situation that arises in these common law vested rights circumstances. That is one way that this came about. The other way is, in order to keep a unified type development going forward, you're balancing the rights. If there's a government approval of a project, it's been built upon, monies have been spent upon it, people have been operating in good faith, and there's changes, then the law says that as you continue with that project, as long as you're operating in good faith, you will still be able to avail yourself of that governmental approval. And that's the circumstances that we have here. And this case that I pointed out, it's the Town of Huntersville case from 2001. And it talks about where property owners have reasonably made a substantial expenditure of money, time, labor, or energy in good faith reliance on a government approved land use, they have a vested right. And this goes to what Terry was saying before. this vested right attaches to and runs with the property, permitting the owner to make use of it in accordance with the government-approved land use. So it's irrelevant how many different owners there's been because it runs with the land. So once a common law vested right is established, which Shad has determined has been established, it runs with the land. So if tomorrow Mr. Shepherdson sells this property, the next owner would have an argument that it runs with the land for them too. Next slide, please. So then the question, we talk about why. Why is it done? Well, it's done to protect property owners and meaning the owner of the property subject to the plan. Then the question is how? Okay, well, how? Well, if you're claiming a common law vested right, then if the zoning administrator is making a determination, he or she would look at these 4 standards. If a landowner was trying to prove a case against the government, they would have to show these 4 things. And again, like I talked about in the general circumstance where case law really talks about these, this is the standard applied when a landowner is trying to force the government to recognize his vested right. Here we have the unique situation where, again, the government says there's a vested right. The government has never taken any action against this property owner. This owner is asserting a vested right, but the government has already determined there's a vested right. So if you're challenging the vested right, you would have to show that the government and the owner didn't present any kind of evidence showing that there could be a vested right established here. And that's just not the case. And importantly, as Mr. Spencer said in his testimony, no part of this standard requires a consideration of neighboring property rights because the government approval has already been made. And when the government approval was made, City Council was balancing those interests at that time. So those determinations about adjacent properties and adjacent uses, those were made when City Council approved this development, which has been built upon. And so that is a question for the rezoning or for the use approval. That's not a question when we're looking at what has been done at vested rights. Further, in Mr. Gatewood's discussion with Mr. Spencer, there was a discussion about, well, what does the case law say? And again, I've already gone through and pointed out that it appears that there's a lack of cases for when an adjacent owner challenges a determination of vested right that's been made. Because like I said, typically these circumstances are a fight between the government and the owner that's trying to assert a vested right. Here, we're in alliance. But there's actually a case, I do a lot of eminent domain work. In fact, the majority of what I do is condemnation when landowners have their land taken by the government. And actually there's a case that talks about vested rights in a development that has been going on for a long time that was subject to a project where the government was taking land. And the North Carolina Supreme Court did a discussion of vested rights when you have a large planned development that takes a long time to build out. In that case is Town of Midland v. Wayne. It's a 2015 case. Town of Midland, just one county over from us in Stanley County. And in that case, there was an approval of a project in 1997 of a customized development plan in 1997. It was residential, 250 acres, residential development. And the Supreme Court outlines and says, although this was developed in 1997, by 2009, the first 2 phases of this development were substantially completed, representing roughly 50% of the subdivision at a cost of approximately $4.6 million. Most of the lots in the first 2 phases had been sold. However, at the time of the condemnation, which affected the remaining undeveloped portion, 40 acres was not developed. and remained undeveloped. And in 2009 is when the condemnation occurred. So 22 years after the plan was approved, the Supreme Court is looking to see if there are vested rights in this development. It's been built upon, most of it's been developed, millions of dollars have been spent, lots have been sold, but there is a section that remains undeveloped. And the Supreme Court is looking to determine if vested rights remain in that portion of the property. And the town argued, and the town is the same group that approved the zoning, is now doing the condemnation, trying to argue there's no vested rights. The town argued that the expenditures that were made on that development were directed primarily at the first two phases of the development, not the undeveloped portion. So when they were talking about money being spent on the development, the town said, well, yeah, money was spent on the development, but it was spent on the developed portion, not the undeveloped portion. And the Supreme Court said, no, when you're looking at the plan, it's a unified plan. It was done in 1997, and the benefit of the expenditures made by the original developer benefit the entire subdivision, including the part that's undeveloped. Again, we're hearing, this is very similar to what we have here. We have a lot of expenditures that were made by the original developer, and we have two pieces that are left undeveloped on this plan. You don't ignore what the original developer did. That's what the Supreme Court's looking at here. And what the Supreme Court points out is the approved plan was developed to provide harmony with the already completed development. Sorry, the undeveloped section would be better developed in harmony with the already completed development under the 1997 plan. And that's what they're saying, and that's what we're talking about here is there is a plan that's in place. It's been built upon. Expenditures have been made. Everybody's relying in good faith. The idea behind these plans is a harmonized development. And here the Supreme Court says, yes, it was done in 1997. Yes, it's 2009. It's 22 years later, but we find that there's a vested right. And they go further to say this defendant, the property owner in this case, gets the benefit of the installation of the infrastructure, preparation of plats and surveys, marketing of the subdivision. These are expenditures that they undertook for the last undeveloped portion, and we don't look at the undeveloped portion separate from the original development. They get to avail themselves of the 1997 plan. So it's unique that we find this in a condemnation case where the government is seeking to take property, but the Supreme Court does a great job in this case of talking about a situation very similar to ours, where you have 22 years that's passed where a development that is done and not fully built out, where expenditures have been made by the original developer. So the Town of Midland v. Wayne Supreme Court case is on point.
Mr. Murray, I'm sorry
Yes.
to interrupt you. Can I ask a
Yeah.
clarifying question there?
Yeah.
You keep saying 22 years.
Yep.
I thought you said that the plan was 1997 and the decision is in 2009.
So the decision is 2015. The Supreme
Okay.
Court decision is 2015, but the condemnation that led to this litigation was in 2009. And so the Supremes were looking at the existing circumstances in 2009.
Wasn't that 12 years?
Am I adding incorrectly?
Because that's 1997 and then
Yeah,
2009.
12 years. Sorry,
Okay,
12
okay.
years. Sorry, I'm adding wrong. 12 years. Regardless, 12 years is more than 3 or 5 years of statutory time.
Understood.
Sorry, I'm a lawyer, not an accountant, and my adding was wrong. So 12 years. Regardless, 12 years is beyond the statutory period. So the Supreme Court was looking at a circumstance beyond the statutory period with common law vesting. The taking was in 2009. It took 6 years to get to the Supreme Court for this determination. But it's still 12 years, still beyond the vested, statutory vested period. The other case that I want to point out to the board, because we actually have an email from the city that we relied upon that I'll get to in a second, is MLC Automotive v. Town of Southern Pines case. And in that case, the landowner was trying to rely upon a very vague approval email, similar to a zoning verification letter, to say that that gave them vested rights to build, when all they had was this zoning verification letter. The zoning changed, and they said, well, we have this verification letter saying that this was the zoning when we bought the property, and now the zoning has changed, so we get to rely upon this zoning verification letter. That's not specific enough. So when you have a determination that's made by the government, a government approval, it has to be specific. It has to be a conditional plan, or it has to be some kind of assertion or statement made by the government to the landowner that you must comply with this standard. So it's not vague. It has to be specific to that property, specific to that plan, and we have that, and you will see that in addition to Mr. Spencer's interpretation. Because again, the city's never disagreed with us here. We've never been at odds with the city. So that's the MLC Automotive Town of Southern Pines case from 2010 that just says you need a specific approval. Next slide, please. So we look at substantial expenditures. What are they? Well, you don't necessarily have to be out there clearing the property. They just have to be expenditures made in reliance upon the approval. That's what the law requires. And that's this North Carolina Supreme Court case from 1969. Next slide, please. Shad has already outlined the expenditures of the larger development. So this slide covers those. I won't go back through those since Shad was thorough on those. Next slide, please. Here's one thing I wanted to point out. This is the adjacent I-1 CD parcel that's outlined here. This is Exhibit 4. As you can see, it has a building on the left side of it. Can you go next slide, please? This is showing the adopted plan next to that building that is built on that parcel. This building was built in 2000, and it was built pursuant to the standards in this adopted plan from 1990. The 20-foot buffer, undisturbed buffer, is in place here. This was built in 2000. So you're 10 years after the approval from 1990. And there's no 100-foot buffer on this property. It is the buffer that complies with the approved plan. So this is from 2000, outside of the statutory vested rights period. This would be a common law vested rights. And this building was built in compliance with the zoning plan in 2000. Next slide.
Mr.
Oh, yes.
Murray, I want to,
Yes, ma'am.
I'd like to, sorry. Wait a minute, let me try this again. Wait.
Let's try it this way. You said it was a 20-foot buffer. I thought the requirement was a 30-foot buffer. Was that just a misstatement on your part?
No, ma'am. On this property, it's actually a 20-foot buffer. So the buffer was actually less on this property than on the property that we have. So the conditional plan on this one, that little, you can kind of see the narrow buffer there. It says end fence south of that.
Right.
That portion there is actually I believe it's a 20. In some cases, regardless, it's no more than 30. But I believe that there's some different buffers being applied throughout. I believe at the time there was some minimum 20-foot buffers, but our property has a 30-foot buffer. So regardless of whether it's 20 or 30, it's not 100. But I believe it's hard to zoom in there, but I believe that this one has a little bit less than what the adjacent property does.
Okay, thank you.
Next slide, please. So when we're looking at expenditures for this particular owner, my client for this particular owner, the purchase price was $255,000, construction loan $1.3 million, development expenditures $114,605. When these development Frank, are you there?
Yes, I am.
You can confirm that these were made in reliance and with knowledge of the conditional plan. Is that correct?
Yeah, that's correct.
And so these are an outline of the expenditures for this particular property owner, in addition to what the original developer had done for this site. And so these are those expenditures. This is Exhibit 6. Next slide, please. So good faith reliance. And this is important because a lot of times what's going on in these cases is a developer finds out that the zoning ordinance is going to get changed. They run down to the permitting department. They try to get a permit so that they can try to lock themselves into the old ordinance. And that's where a lot of these fights start. But that's not what's going on here. While they're doing due diligence, they found the conditional plan. They looked at it. And in fact, they had some questions about this buffer. And the engineer actually contacted the planning department, the plan review people, to confirm the development plan was still in place prior to the development expenditures and the construction loan. And if we can go to the next slide. This is the communication with the planning department, Exhibit 7. Katie is the engineer for our developer. For our site. And it's to Kelly Robertson, who is the zoning plan reviewer. Kelly, I'm the commercial zoning reviewer for this area. The rezoning plan governs the setbacks and buffers. It says and, but he means and buffers. There was a question from us about what is, it doesn't seem like there's a description for us on this undisturbed buffer area. And he states, the rezoning states that the 30-foot buffer area shall be undisturbed. The drawing shows the location of the fence. The buffer area should be scaled at 30 feet and remain undisturbed per the rezoning plan. Let me know if you have any questions. So this is a communication from May 24 of this year from the city confirming that the city is relying upon this rezoning plan. This is not simply something that we went out there blindly, looked at the plan, and started spending money. There was actually a communication because this came up. It was a question, and the engineer went to the city, and the city came back and said, the rezoning plan governs the setback buffers. This is the specific communication from the government here, in addition to Shad's interpretation. This is Exhibit 7. Next slide, please. Get valid government approval. Conditional plan from 1990. It was developed as part of a master development plan. Other parts of this development have been built out. The city has actually continued to rely. The city is doing a development on a portion of this property that's zoned I1 CD, I2 CD. City actually owns a piece of the property in here. No parts of the development have a 100-foot buffer. And in fact, this property wasn't designed for a 100-foot buffer because it eats up the whole property. And then on top of that, the email that we have from the city affirming and confirming that governmental approval and reliance upon the 1990 plan. Next slide, please. And then in this next part is about the party's detriment. Mr. Spencer's already talked about this, as well as Ms. McCarter. about the 100-foot buffer, if it was applied like Mr. Gatewood and Mrs. Gatewood would think should apply to this property. Basically, if a 100-foot buffer applies to this property, you're creating a substantial hardship, possibly even a taking of this property, because it cannot be developed with a 100-foot buffer. Next slide. As you can see here, this is Exhibit 8. This is the development plan. Frank, could you explain to the board what's shown on this plan, please?
Yes, this plan shows 2 warehouses on the right side and a row of smaller buildings separate from that large building. The building is respects the 30-foot buffer, and there's a fence line along a wooden fence along the 30-foot buffer. And on the left, where the shaded area is, that would be dedicated to the city as a tree save area.
And Frank, how were the sizes of those buildings? How were those determined?
I'm not sure if I understand your question, but why did I choose to make them those sizes?
Yes.
We have need of a facility, my company, my business, and I will occupy a building of 50 by 100, and next to that, there will be another portion which is also 50 by 100. So that building on the right is 100 by 100 approximately, which is the right size for our kind of business. And then the others would be for tenants, and that would be, those are convenient sizes for tenants, which would be 25 wide by 50 deep with a roll-up door. And we believe that that's the size that the market demands.
Next slide, please. This is Exhibit 9. Frank, can you describe what's shown here?
Yes, the colors are wrong. It's going to be gray on gray, and the building on the top is the 100 by 100 building, which is at the right side of that plan that you saw. The part that faces the residential property would be the one with the single door on the right side. And then the building below is the row of rental spaces, which are, as I mentioned, 25 by 50 deep.
Next slide, please. This is Exhibit 10. Frank, is this a fair picture of a example of likely what the structure would look like?
Yes, this is the side facing the parking lot. Obviously, the back side is similar to the other slide where there's a door. So there would be all the activity on this side and none on the back side.
Thank you. Next slide, please. Members of the board, this is exhibit number 11. It's actually the grading plan. So some plans have been in plan review. And according to Frank, grading permit issuance is forthcoming. I would like to point out to the board, the city has never tried to stop development of this property because they believe there's vested rights. So there's never been any permit denials or anything like that for this site. And so we've been operating under the conditional approval as well as Mr. Spencer's interpretation as this moves forward. And so just like to point out, grading permit issuance is forthcoming, but this shows in green where the 30-foot undisturbed buffer is currently. Next slide, please. This is showing on exhibit 12, this is showing with the structures on the site where the 30-foot undisturbed buffer would be located. Next slide, please. This would be if there was a 100-foot buffer on the property. And you can see that it would eat up the majority of the developable area. It would essentially have enough space for a driveway and a, maybe a building at the end. No room for maneuvering, no room for double rows of parking. And this was not developed, this was not subdivided. This plan was never done with a 100-foot buffer in mind. Next slide, please. Mr. Spencer had stated before, if the property is viewed by itself, so if there's not vested rights, meaning it's not part of this development any further, then the new buffer that would be applied, if it's not 100 feet, it could be reduced with a berm to approximately 41.25 feet. And that still impacts beyond what this development was originally planned for. And it impacts the ability to do the development plan that the landowner is seeking. So this is Exhibit 14. Next slide, please. There was some discussion, again, we don't believe that it's relevant here, but I'm dealing with it because it came up in discussion. Frank, can you describe this exhibit, please? This is exhibit number 15.
Yes, we examined city records to review what had sold in the recent past in adjacent areas and the possible impact that the industrial site might have on properties in the area. And what we determined were these were the values that properties sold at and the dates that they sold. There were several sold in the very recent past, meaning a matter of 3 years, but there were more sold along the common boundary in the last 12 years. But this shows the increase in value and the current valuations of properties that exist.
So Exhibit 15, what Exhibit 15 showing is, especially if you look at number 5, 6, and 3, those have back up to an industrial building that is approximately the same distance that a building that would be built on this property would be built. And 5, there was an increase in value each time it was sold, even up to 2019. 6 was sold in 2019. 3 was also sold, and the values have increased each time. Next slide, please. Exhibit 16. I just did a rough measure here. Frank also confirmed it, but according to GIS, the buffer to the fence on the adjacent property is 30 feet. And so it's a good comparable to what would likely be somewhat similar, although that parcel is larger. So that building is larger that can go on with this tract, but a similar comparison to what's already out there. And again, that those houses that are adjacent to that sold and were not negatively impacted. Next slide, please. So members of the board, I thank you for your time. Frank and I are happy to answer any questions. But based upon Chad's presentation, our presentation, the case law that we've cited, common law vested rights would exist on this property. It's definitely a unique situation, but the government has never been against this property owner, has never denied any rights to this owner. And so the determination on vested rights is a determination to be made between the city and the government. And in this situation, we believe that the government should be approved. The city should be affirmed in their decision that there's vested rights. Thank you.
Thank you, Mr. Murray. Does the
Oh,
staff have any?
Mr. Wilson, sorry, I have one more thing.
Yes.
Mr. Shepherdson, do you adopt as your own testimony the statements and presentation that I have made on your behalf here today?
Yes, thank you. I do.
Thank you. Thank you. Mr. Chair, that's all
Thank-
for me. Thank you.
Okay. Thank you. Thank you very much, Mr. Murray. Are there any questions from Mr. Murray from the board?
Mr.
I do
Murray,
have
got-
I'm
one.
sorry.
I have
I
one.
have, I have one. Go ahead.
Okay.
Go ahead, Deborah.
Yes.
Mine, let's go back to the exhibit 13 or exhibit 10, one of those. Sorry.
Yep.
And I see, I'm interested in this. Is this on the far right? What is that? Is that the trash container? Is that where you're going to put the trash?
Oh, this is just an example of another site.
Oh, okay.
That this is just a different site, just to show the board what kind of architecture generally it's going to be consistent with what's out there. But we assume somebody on the board might have a question of generally what we're looking at building instead
Okay.
of just the black and white plans. But this is a different site.
Okay, and then one of your exhibit 13 shows arrows that point. Is this the driveway on the far right? Why do they have the arrows pointing toward the buffer?
That's,
there
can I
access to the
answer
back
that,
of-
David?
Yes.
Ma'am, that's this is an overlay on an architect's, on an engineer's drawing. So those are, I believe that's water flow
Oh,
that
I
the
see.
engineer determined. Also, you asked a question about the dumpster. On exhibit 13, you can see where the dumpster would be located. And there would be nothing built on the south side of our property. In other words, all that the way that we've got it here is that only the back of the property would be facing the residential portion with trees.
Okay, and you are planning to because the other plaintiff, Mrs. Gatewood, talked about you cutting down all the trees. So are you leaving some trees, or are you planning to just plant new trees?
Heaven forbid that we would cut any trees in the undisturbed buffer, ma'am. We didn't cut any trees in the undisturbed buffer, and we would keep as many trees as we possibly can in the rest of the area.
Thank you, Mr. Shepherdson. That's all.
Mr. Floyd, you had a question?
Yeah, Mr. Murray,
Yep.
you talked about the town of Midland case and that kind of 12-year gap. I guess as I tried to think of what the arguments that Mr. Gatewood was trying to raise, it seemed like he raised two issues. One was, whether common law vested rights run with the land. I think you answered that question with a citation that quotes from case law. I think the other one he tried to raise was kind of at some point the common law vested right lapses. I don't think the law in North Carolina, at least my understanding, is not very clear on when that occurs. But he pointed to, look, under the statute, you've got some limits. And I was just wondering whether you have any thoughts on that issue. And then also if you could talk about the history of this development and when properties have been constructed. You mentioned one that came online in 2000. Was that the most recent one, or have there been other buildings within this development that have been constructed along and along?
The city is building one right now in an I-2 CD to the north part. And this has been a slow infill. So if you look back at aerial pictures, it hasn't necessarily all been all at once. Now, there were developments, right off the bat.
Mm-hmm.
The thing with the vested right issue, though, when we talk about time frame, is if you don't operate and you don't immediately start taking actions, you can't assert a common law vested right. So a common law vested right is triggered because you've actually done construction and a development has been put into place. if nothing has been done and you say, oh yeah, my statutory vested right ran, but I have this common law vested right, well, you still have to show that you relied in some way upon a governmental approval. And so to answer your question, the city themselves made the determination that this still applies. Okay. So there was an email that the city review still applies this plan. So, and that's because it's been built out. So I'm not sure that there is a deadline because case law doesn't give us a deadline. And I think the reason for that is this whole idea that the Supreme Court talks about is once this thing has been built, and just because there's some undeveloped parcels, the intent that this was supposed to be all in harmony still remains. And so you're still looking at what is actually taking place out there. Has there been movement towards building this out? And here there has been movement towards building this out. And you get to a point where you go, okay, there have been developments taking place under this development plan. We have one that the city's doing to the north that is actually under construction. We have one that was in 2000, and I think there was another one in between those two. I'm not sure off the top of my head. But again, this isn't just Shad saying there's vested rights in this whole development. This is also a situation where this specific property owner had the circumstances that gave rise to a vested right themselves. So we have two layers here. We have Shad's interpretation that the development itself has vested rights. And then we have the layer of this property owner actually did the due diligence to confirm with the city that this was what they had to comply with. They have an email from May confirming that they have to comply with this plan. They did expenditures upon that plan in good faith. And that's how we got here. And so I don't know that you can ever really establish a deadline if the development is still going forward. I think if it sits there for a substantial amount of time, nobody ever does anything, and you just show up one day and say, I have this development plan. If the government says you don't have it, now you're in a fight with the government, because that's what all these cases are about. But this case is different because we have the governmental approval. And so we've relied upon the governmental approval. And it's not just the conditional plan, it's also the email from the city and Shad's interpretation. So we have multiple layers of approval here that in all these other cases don't exist. All the other cases are the government putting their foot in the sand and saying, we're done. We're not upholding this vested right anymore, which is the Town of Midland case. And the Supreme Court saying, no, there's evidence that this was built in reliance. You have to uphold what you've been done to create harmony in this development, and they have vested rights to continue here. And that's why the Town of Midland case, there's just not a lot of cases on point for this situation. And that does make it difficult if I'm trying to cite a specific case to you. But the Midland case is the closest one that I could find on this situation. But again, I didn't find one where the government and the owner were aligned, where the court was trying to determine the adjacent owner's right, if any, on a development that they were not a part of, which is more of what our situation is here. But I do not believe that this time period would be unreasonable as things have been developing in this industrial park. And I think there was one other piece of your question I think I might have forgotten.
No, I think that was it.
Okay. Okay.
Mr. Murray, I have one quick question, and I
Yes.
don't know if this applies here, but was any type of communication required to be sent to the homeowners from Mr. Shepherdson that there was going to be development of this industrial park?
No.
Okay. Thank you. Are there any other questions from the board for Mr. Murray and Mr. Shepherdson?
I have a comment.
Okay. Oh, yes. And I was coming to you, Mr. Gatewood, next, actually. I just want to make sure if there are any other questions from the board. Okay. Hearing none, Mr. and Mrs. Gatewood, you do have a chance to ask Mr. Murray and Mr. Shepherdson questions.
First of all, I will, in the spirit of fairness and the procedures for a quasi-judicial hearing that requires that the protocols be adhered to as any other judicial proceeding, I would like to object to this entire presentation. The reason I would like to object to the presentation is because on September the 20th, 2021, I sent an email to Mr. Chad Spencer, and I asked him to make available to me any presentation that would be made by the owner or the any information or presentation that would be made by the owner or the board or the zone administrator. He sent to me. I asked for that information on September the 20th, 2021, and I did not receive it. I received the finding of facts on September the 28th, day of the hearing, 33 minutes prior to the beginning, prior to the hearing started. The hearings were to start at 9 o'clock. I received my finding of facts at 8:27 on the day of the hearing. And according to a letter that I received from Mr. Murray, he received that information at least by September the 22nd. So because I have not had an opportunity to review this information, and because of course these hearings are subject to the Fifth Amendment due process rules, I object to that entire presentation because I have not had a chance to review it and therefore cannot make a rebuttal to it.
Can I be clear? What did I receive on September 22nd?
Well, I believe that you received the finding of facts.
No, I would have received the finding of fact whenever anybody else received the proposed findings of fact. I also didn't have your presentation. I was emailed the proposed findings of fact by Terry this morning at 8:43 at 8:43.
Well, it's obvious that you had talked to him because you wrote me a letter saying that you had.
Yeah, I can have communications with the zoning administrator about your appeal. Yes, I can.
Let me interject here real quick, Mr. Gatewood. Are you referring to findings and facts of law that was sent out from our September 28th meeting when the appeal was on that original agenda? Are you referring to that?
That's what I'm referring to, yes. I received those finding of facts 33 minutes before the hearing was to start.
That's correct.
According to a letter that I received from Mr. Murray, he referenced some points in that finding of facts on the letter I received from him on September 22nd. So what I'm saying is, in the spirit of fairness and the due process afforded by the Fifth Amendment, that entire presentation that he just made should be rejected. I object to it.
Just so I can testify on the record, I did not have any findings of fact on September 22nd of 2021. All I had done was I had discussions with Mr. Spencer on his interpretation. I had reviewed Mr. Gatewood's appeal, and I stated to Mr. Gatewood that I believe Mr. Spencer was on solid ground. But I do not believe that I didn't. Shad doesn't send me findings of fact until right before the hearing, just like he does everybody else.
Okay, well, I just thought it was a coincidence that the letter you sent me referenced a specific section of the finding of fact. So my question, so I'm still saying that this entire testimony should be, I'm objecting to it.
Okay, I guess this question should go to our city attorneys, Cherie, make sure I'm saying the name right, and Jill. What is your take on this, on Mr. Gatewood's objection that he objects to this entire presentation?
I'm trying to understand it. I guess I'm trying to understand the objection to the entire presentation. Because I'm hearing findings of fact, but then he's objecting to the entire presentation. And I'd ask Mr. Murray and the zoning administrator, if the entire presentation that Mr. Murray gave was available to the zoning administrator.
I had to submit it on September 22nd. Under the rules, I had to submit my presentation, I believe.
Okay. And so Mr. Gatewood, and none of this information was available to the Board of Adjustment before today. Is that correct?
I don't know when it was made available to the Board of Adjustment, but it has not been made available to me.
Just to be clear, I didn't have Mr. Gatewood's presentation ever. It was just as I'm watching it at this hearing right now. So.
Yeah, I'm not sure that there's a requirement for, I know that there's the government will provide information to the applicant prior to the hearing, but I'm not sure that there's a requirement that another party also provide that information.
Oh, well, my presentation did not include slides. It did not refer to building structures. It didn't refer to case law. Basically, what he was showing was evidence, and in the evidence that is presented, it's supposed to be presented to all parties prior to the hearing. There's a difference between what I presented and what he presented. He presented evidence.
What did you present?
So
I'm
is
certainly
there,
not aware of any requirement that says Mr. Murray has to share his presentation with the applicant. From a procedural perspective, Mr. Chair, I mean, are we supposed to consider this objection and decide whether or not to to accept Mr. Murray's testimony in his presentation? If that's the case, my vote would be that we overrule the objection and accept Mr. Murray's presentation and move on.
Okay. Okay.
And I'm not aware of any rule or requirement. It's not in our rules of procedure. So I would just like to note that for the record, and that the proposed findings of facts are not evidence. They are a proposed draft of something that the board can consider. So just wanted to make that clarification as well.
Okay, great.
Okay, I'm not saying
Okay.
that finding of facts is evidence. So understand Mr. Floyd said he objects to the overruling my objection. So what's the rest of the board take on it? Question.
Got you. And so, Mr. Gatewood, if I'm hearing you correctly, your objection is not findings and facts of law. Your objection is the part of the presentation from Mr. Murray where he presented slides and diagrams of the property, et cetera. And your concern is that you did not receive that or had time to review that. And for what I'm hearing from our city attorneys and from one of our board members right now is that that is not required of parties to present their presentations to each other ahead of time. So that is why we're hearing an objection to your overrule.
Okay, well. So you're saying the board is overruling my objection? Is that the opinion of the board?
Well, that's what I'm trying to get to now, and according to the rules that I can rule and I can object myself as well in representation of the board.
So you object? Go ahead, I'm listening.
Yeah, yes, yes, sir, I am. However, I still want to give you the opportunity to ask questions to Mr. Murray. In this case, rebutting him based upon what he presented to us.
I just like to make I would like to, of course, this is not my final rebuttal, but I just like to comment on what he said, a couple of things he said. And one thing he did say that I was in total agreement with, and I was in total agreement with that. It is unusual for the government be on the side of the builder against the public. That is unusual.
I have to object to that characterization.
Well, I object. I'm saying I agree with what he said, that normally the government is on the side of the public.
Just so I'm clear, the case law that is in the Court of Appeals in the Supreme Court is typically dealing with a situation where the government and the landowner are fighting each other. That's what I'm talking about.
Okay. And of course, in what he was saying, also he brought up a case law. And of course, and I like to, there was a case back in 1999 for the Massey versus the city of Charlotte and the Albemarle Land Company. Of course, in that case, the city of Charlotte was actually on the side of the petition of the Masseys. In that particular case, where the Lowe's was trying to build a big box warehouse adjacent to a residential property. In that particular case, the Massey case, the Albemarle Land Company was actually proposing a 100-foot buffer. They were proposing a 100-foot buffer, and still, the city of Charlotte objected to them building that building. In the Massey case in 1999. So it's going back to what he said, that it's unusual for the government to take the side that it's taken. Because the fundamental purpose of government, as I understand it, is to protect the weak from the powerful. That's the fundamental purpose of government, as I understand it. But also he talked about the 12 years, the 12 years in that case, and of course, and from what I'm understanding, if it was only 12 years and they had a development agreement, well, whether that was right. That was right. I mean, they had a vested right. If they had a development agreement, because the development agreement can last up to 20 years. In that case, it was only 12 years. He talked about this building that's over there adjacent to that property. Well, in my opinion, that building was built illegally, but I mean, that's a subject of another session. But I have no more questions or any more comments on that. We just, and where are we in this hearing?
Okay. Thank you, Mr. Gatewood. Well, at this point, I just want to make sure I ask Mr. Murray if you have any response to what Mr. Gatewood said. And if not, then Mr. Gatewood, we would then end the hearing and then we would go into deliberations, which you were.
Actually, I have not presented my rebuttals. My closing statement.
Oh, okay. Yes, I just want to make sure that I want to give Mr. Murray a chance to respond. And then we'll go to your closing statement, and then we will go to deliberations.
The Massey v. City of Charlotte case is a case that says the City of Charlotte can engage in conditional use zoning, which is actually what it did in 1990 here on this property. Other than that, no further comments. Thank you, members of the board.
Okay, thank you, Mr. Murray. Mr. Gatewood, you can now present your closing statement.
Well, the point that I was making was that the City of Charlotte, even with that case, there was a 100-foot buffer, and the City of Charlotte still went against the land developer. That's the point that I was making. But at any rate, I'm just going to go down several lines of what's been stated here. Starting with section number 5 says the property located in the general commerce center industrial subdivision comprised of parcels of land, et cetera, et cetera. The general commerce center purchased this parcel of land 9/27/20, which is 097-223-05 in 1989. That's when the general commerce, they purchased this property. And they sold it to Economy Waterproofing in 2004. And that parcel of land was not developed by the General Commerce Center. Then I'm moving to section number 8. There's the per code section 6206 of subject parcel is bound to the approved conditional zoning plan and governed by a governmental predetermined ordinance, etc. So if there's no vested right has been established, the owner is bound by the code at the time that the land was purchased on April the 15th. There was no vested right established, and so far, no one has made any presentation that established a vested right for this owner. And then we'll look at section number 10. Therefore, since the subject property is in a conditional zoning district, is subject to the specific standards and conditions of the 1990. Now, conditional zoning district has no privileges over a traditional zoning. Matter of fact, the provisions on a conditional zoning are more restrictive than those of a traditional zoning. And then, of course, I go into section number 11. It said per code 6.207, any deviation from the conditional zoning plan for the General Commerce Center requires an amendment to the conditional zoning. It says there should be a development agreement recorded with the Register of Deeds per North Carolina General Statute. Also, the maximum duration of a development agreement is 20 years. Any renewed agreement requires a public notice and legislative hearing. I am not aware of any public notice being given, and I am not, or any legislative hearing taking place. Also in section number 13, it says simple conditional rezoning approval, any change to the general commerce and development have required amendments to the conditional zoning plan. Administrative amendments to the plan have been approved as recently as October 12, 2010. Of course, that's 11 years ago, and I don't really consider that recently. However, October 12th, 2020 is likely the date that the original development agreement expired. The original agreement was dated October 15, 1990. Per North Carolina General Statutes, public notice and legislative hearing would be required to renew the agreement. And number 14. The applicant's appeal includes a reference to code section 1.10, stating procedures for establishment of a vested right or absent with respect to the adjacent property. However, per code section 6.206, the condition of rezoning for the subject property approved on October 5th, 1999 is exempt from those requirements per code section 1.110, applies to conditional zoning district approved on or after October 1st, 1991. And of course, and then it goes on to say in number 15, although not subject to code section 1.110, the property is subject to vested rights are provided in North Carolina General Statute, section 160D-108, statutory vested rights, as well as common law vested rights, which is authorized in case law. Here again, we're still talking about case law, and Mr. Murphy has already said that there's not a lot of case law on this, so why bringing up case law if there's no case law to support the determination. 14 and 15, the code section 1.110 was presented to me via an email in an attempt to prove that the current owner has a vested right. I got that code via email. I got that from the email from the Zoning Administration Office, stating that they presented that in defense of a vested right for the current owner. And now the Zoning Administration is backtracking in their assertion that the code section 1.110 does not apply. And of course, that's an exhibit B2. Code section 1.110 is pursuant to, of course, that means based on, according to, in accordance with the North Carolina General Statute 160D-108. If the North Carolina General Statute 160D 108 applies, then code section 1.110 must apply. Otherwise, there will be a conflict between the code and the statute. This owner has taken no action to establish a vested right per code 1.110, nor North Carolina General Statute 160D-108. Furthermore, the zoning administrator does not cite a specific section, in North Carolina General Statute 160D-108 that gives the current owner a vested right, nor does he provide a case to support that a vested right for this owner is authorized in case law. And number 17. The zoning administrator's interpretation that the subject property has common law vested rights from previous government approval. The procedure for establishing a vested right is predicated by the actions taken by the owner of the property. From North Carolina General Statute 160D-108 and Code Section 1.110. And then number 18, he says North Carolina courts have recognized common law vested right. He goes on, and the key word here is the owner must. Key word is the owner must. And another key word that's missing is once established. That's when it transferred with the land. Is once the vested right is established. The vested law can't. The vested rights can't be transferred until they're established. Per North Carolina General Statute 160D, no vested right has been established by this owner. Another key phrase is an owner must. We go down the list, and it's talked about what the owner must do. It says the owner must obtain an approved building permit, which is a government approval. And what government approval has this owner received? Now he talked about the government approval that the owner received, but that was after current ordinance and buffer requirements went into place. That's the government approval that he presented. And of course, the current zoning ordinance and buffer requirements were already in place at that time. And of course, G And the General Commerce Center, they sold that property in 2004. Property was sold by General Commerce Center in 2004, 15 years after they bought it in 1989. And GCC never developed that parcel of land and has not owned it in 17 years. And the development agreement expired October of 2010. And there has been no active government approval for the current owner to rely on. In April 2021, we purchased the property. Current owner made no expenditures prior to the code change in 1992, when the current code took effect. Current owner purchased the property April 15, 2021. Therefore, no vested rights exist. And acting in good faith, buffer requirements in code section 12.302 were in effect when the current owner purchased the property on April 15, 2021. GCC sold the property in 2004. As a real estate broker, because Chad mentioned the value of the property in the General Commerce Center and the other part of the industrial park. And so, as a real estate broker, I estimate the value of the property in Bridlewood community to be at $61 million, which is a R4 residential zone that abuts the General Commerce Center and the remainder of the industrial district. The effect of applying the current buffer requirements the effect of not applying the current buffer requirements as outlined in Code Section 12.302, Class A buffer with a 100-foot width has the potential of a devaluation of property. Of course, that was part of the consideration that we took in the Massey case, and when the city sided with the residential property owners. The effect of not applying the current buffer requirements as outlined in Code Section 12.302, a Class A buffer with 100-foot width has a potential devaluation of the property in that neighborhood, as well as the residential properties in the surrounding subdivision. Use of comparables, that's what we use in real estate to determine the value of property. Bases the value of property on the value that like property is sold for in a close geographical area. If I have to sell my property for $30,000 less, because an industrial building in close proximity, it affects the value of other homes in the Bridlewood subdivision as well as homes in the surrounding subdivision. The valuation of property could also result in a huge loss of tax revenues for the city of Charlotte and Mecklenburg County. Also, it would be a devastating blow to the economic well-being of the residential property owners affected by this decision. Giving priority to the industrial district over the R4 residential district is not good for the property owners, the Bridlewood community, and is not good for the city of Charlotte, Mecklenburg County. Given prior to the R4 residential districts and applying the buffer requirements in Code Section 12.302 would better serve the purpose of the code in Section 1.102. Then, of course, he talks about the current owner experiencing detriment. Buffer requirements in Code Section 12.302 were in place when the current owner purchased that land on April 15th of 2021. Those buffer requirements were already in place at the time. Land parcel in question was purchased from Condiment Waterproofing by KBT Industrial Land Trust, August 27, 2020, for $15,000. The land parcel in question was purchased from Economy Waterproofing by KDT Industrial Land Trust, August 27, 2020 for $15,000. KDT Industrial Lands transferred deposit to
I'm sorry to
0972.
interject, but I thought we were at a point where Mr. Gatewood was making a closing argument. It seems like he is continuing to put new evidence in the record. Can we?
Well, actually, I'm doing a rebuttal, which of course is what I'd say that I can do.
Yes, Mr. Gatewood, I was just about to interject. We have a board member that has to leave in the next 4 minutes, and I want to make sure that we have some time to deliberate on this case before we may lose quorum. So not trying to, rush you here, but I want to make sure that we are fair and be able to deliberate on this case. So if you have a closing, please present it.
Well, Mr. Murray, now his presentation is a whole lot longer, was a whole lot longer than I already spoken. And because of the order of the procedure, I don't think I should have to rush my presentation. That's where all the time went.
Okay.
We've been put off twice. We were ready to make our presentation in the August meeting. We're ready to make our presentation in the September meeting. And then of course, we got a date after that was put off, and now here we are now, and we're being told that we don't have time to make our presentation.
I'll just object here. Mr. Gatewood stated he was doing a closing argument. Our presentation, I believe, was actually shorter, but regardless.
And Mr. Gatewood, we're not trying to rush you at all. We just have some board members who need to leave the meeting soon. And if we are unable to deliberate on this case, we would then have to, again, move the deliberation until November. And we, like you said, we've been, this case been put off twice. So that's why I was saying that, not rushing you at all. That's why I was saying that, just giving you a heads up that we are getting close to the time when board members will be leaving. So.
Well, I don't have a whole lot more, but I don't want to be rushed because nobody else has been rushed.
I understand.
And of course, and this is a rebuttal to the presentation that was made by the zone administrator. I'm going by line, which it says, and according to the procedure, it says the applicant can make rebuttal and closing statement.
Yes, you are correct. I was just letting you know that what we currently have going on is that
Okay.
Yeah, that's all. We're not rushing you at all. I was just letting you know, like I definitely want the board to deliberate the case, and I was just letting you know that we may have some board members that may have to leave. They may can come back this afternoon, but I just want to make sure that we're able to hear this case.
Okay. Okay, as I was stating, the KB Land Trust transferred this parcel to the Industrial Land Trust and be a quit claim deed with, because keep in mind, zone administrator is the one who brought up the value of property in the general commerce center. That's where this land is going. I didn't bring that up, he did. The Industrial Land Trust transferred the parcel to 097220305 Industrial Land Trust via quit claim deed with no dollar amount stated on December 9, 2020. 097220305 Industrial Land Trust sold the property to Washburn 3100 Inc. on April 15, 2021 for $250,000. Now, I don't believe that if the Economy Waterproofing company thought that parcel of land was worth $255,000, they would have let it go 14 months ago for $15,000. So finding out if you can use a parcel of land for the reason it was purchased. In real estate, that's called doing your due diligence. And that's done before you buy property, not after. It is not the job of the zoning administrator to seek relief for purchasers, for land purchasers that make bad real estate investments. That's not the role of the zoning administrator to seek relief.
These regulations are.
Somebody purchases a piece of land they can't use it for what they bought it for, give them relief. In the hierarchy of zone maps in Charlotte-Mecklenburg, the R4 residential zone is at the top of the industrial, is at the top, and industrial zones are at the bottom in the order of priority. If there is any ambiguity in the code or statute, and I don't believe there is, and just like Mr. Murphy pointed out earlier, generally the government it's an odd situation for the government to be in. This is an odd situation for the government to be in. But the government is generally on the other side. And I don't believe that it would, there's any ambiguity in the code or the statute, and I don't believe there is, it would be reasonable to give deference to the R4 zones, which is the less intrusive zone, and that would better fulfill the purpose of code section 1.110. Now, the next item is item number 19. Item number 19, the zoning administrator's finding of facts. He states the zoning administrator's assessment that the General Commerce Center meets the criteria for common law vesting. It has been established that the General Commerce Center Development does not own this property. And they have not owned this property in 17 years. And then, of course, when we go to section number 20, because the zoning administrator says the applicant references code section 1.102 on the appeal application and states authority and purpose of the code is not being fulfilled by applying a condition set 31 years ago. The zoning administration's determination adheres to code section 1.102 because it utilizes and considers the authority granted to the city of Charlotte by chapter 160D, articles 1 through 14 of the general statutes of North Carolina, and by any special local legislatures enacted by the General Assembly for the city of Charlotte. Now, this particular section number 20, in my opinion, requires special attention. Because generally in the cases that I've looked at, and I've looked at a lot of cases, generally if there's any ambiguity, the courts have generally sided on the aggrieved party. Now, when carefully reading the finding of fact document for my case, I noted an egregious misinterpretation of my intent expressed by referring to code section 1.102, authority and purpose. My statement, which the zoning, my statement, which the zoning administrator cites are even false. Authority and purpose of the code are not being fulfilled by a plan of condition set 31 years ago. By making this statement, I am in no way questioning the authority of the zoning administrator. and I'm not questioning the authority of the city council or any governing board to execute their official duties as the zone administrator's response in item number 20 implies. However, I maintain and defend my statement along with the intended meaning. Upon close examination of my statement in the specific context in which the word authority is used, the authority of the code, the word authority is used in this specific context to emphasize the legal power or authority that is embedded within the code itself as a compilation of written regulations enacted through legislature. Although I'm not questioning local government's authority, as the zone administrator's citation implied, and also as Mr. Murphy's presentation implied, I am in fact questioning any attempt to circumvent the authority and provisions of local ordinances and statutes, or any amendments that have been made in order to better serve their purposes. Section 1.102 of the Mecklenburg Ordinance clearly states the purpose of zoning regulations. These zoning regulations have been designed to lessen congestion in the streets, to secure safety from fire, panic, and other dangers, to promote the general welfare. In addition, Chapter 3, Part 3 of the Mecklenburg Ordinance goes on to explicitly state the purpose of these regulations pertaining to buffers and screeners. General purposes of this section are to establish regulations protecting and preserving the appearance, character, and value of property within county, and to recognize that the transition between certain uses require attention to protect the less invasive land uses in abutting zoning districts. First, Charlotte Mecklenburg zoning maps, the subject property is located within subject property 1700 Industrial Center Circle is located within a 1-1, 1-2 conditional zoning district that abuts the R4 residential zoning district in which our property 6123 Old Coach Road is located. Now, Mr. Murphy, he did mention that there was some other construction that was going on in the I-2 area. But of course, the construction that's going on in those areas do not abut residential property. That's one thing I like to point out. That construction does not abut residential property and is more than 100 feet away from residential properties. Therefore, in order to protect the less invasive land use, the R4 district, required attention should be provided to protect the R4 and its R4 property and its residences. According to table 12.302, the transition between the abutting properties requires a Class A 100-foot buffer as specified in section 12.302 of the January 1992 Mecklenburg Ordinance, which is well before Mr. Jefferson purchased this land April 15 of 2021 and has been codified through June 15, 2021. Adherence to these regulations will better serve the purposes for which zoning regulations are intended as detailed in 1.102. In number 22, he says the applicant also references code 12.2 stating buffers and screeners are not being applied to respect to the subject property. The subject property applicant states that the subject property should be subject to current buffer regulations, which assert is a 100-foot Class A buffer. Well, that is not an assertion. That's a fact. The fact is that should be a 100-foot Class A buffer Class A buffer, and that's not a fact. That's in the code. It's in code 1312.302. And then, of course, in number 23, so the approved zoning plan for the subject property requires a 30-foot wide undisturbed buffer and a 7-foot fence on the southern boundary abutting residential zone properties. This buffer, which exceeded the minimum buffer standards in 1990 section 1601, and affected the time of the city council approval. The conditions of the approved plan in 1990 are irrelevant because no vested rights exist. There's no vested rights, and if there were any vested rights, they have expired by any of the codes you want to, or statutes you want to look at. You want to go all the way back to the 1985 statute enactment, the 1992 statute enactment, or the 2020 statute enactment. That statute does not give this owner any vested right. And then we're going to section number 24, the zone administrator determination that the 30-foot wide buffer and the 7-foot tall fence shown in the 1990 conditional plan is required for buffer requirements of the subject property. The subject property is 2.6 acres, and the total area of the general commerce plan center development is greater than 10 acres. Now, to me, to bring in this 2.6 acres, now they've been, all their presentations have been attaching this to the general commerce center. But the general commerce center is not the issue. The issue is the rezone district. Because the general commerce center was not the only district, was not the only parcel of land that was rezoned during this rezoning that took place in 1990. And to me, this is just my personal take on this. This is it's just an attempt by the zone administrator give the developer, Mr. Shepardson, another way out. The current owner, in order to give the ZB, trying to give him another way out by circumventing the 100-foot buffer requirement in the statute. And of course, anytime you take one parcel from a rezoned district and give it special treatment over the other parcels, that's called spot zoning. And when spot zoning is done in this manner, that is suggested by Mr. Murray.
I'll just point out that I did not suggest anything about spot zoning, nor is that even relevant to what's under determination here.
Well, you didn't mention the word spot zoning, but the way you define that would create a spot zone.
Zoning board can't rezone property.
What zoning board? I understand that. I understand that. But I'm just trying to figure out why that was even brought into the conversation about taking this parcel out of the complete rezone district. Why did this even come into the conversation? But anyway, I'll move on from that. The previous approvals for the general commerce area are irrelevant because the statute refers to only approvals that have been made by the owner. And of course, the zoning administrative office has not made available any approvals have been given for this only. The only approval that I have seen to date was the approval that Mr. Murphy presented. And of course, that approval was granted after the zone ordinance changed, which required a 100 Class A 100-foot buffer. Now, Chad, he also said that the zone administrator determination that such property has come of law vested right, that if the zoning administrator determination that such a property as vested right is overturned, it will result in a precedent for other parcels located in a planned development within a conditional zoning district and would negate their development rights and entitlements under their approved plan. Well, if the zoning administrator's job is to apply the code, to interpret the code, and to enforce the code. It's not to try to determine what the effect of would be if the code was applied properly. Only to one side. It's not the zoning administrator's job. And also, maybe some of the attorneys in the room can help me on this, but it's my understanding that the quasi-judicial hearing cannot set a precedent same as case law or a legislative hearing. That's my understanding. A quasi-judicial hearing cannot set a precedent same as case law in a legislative hearing. So, and the most distinguishable difference between a quasi-judicial hearing and a legislative hearing is that a legislative hearing can set a precedent and a quasi-judicial hearing cannot. So why this was actually put in there, here again, I'm a little bit confused about that. Now, as I stated earlier, and I'm wrapping it up, as I stated earlier, I was taught to believe that the fundamental purpose of government is to protect the weak from the powerful. And of course, then like Mr. Murphy said, generally the government is on the side, does not generally is on the same side as the land developer. That's an unusual situation. And I was taught to believe that the fundamental purpose of the government was to protect the weak from the powerful, and not the reverse. So in my closing, this owner does not have a vested right according to common law, because its owner did not take any of the do anything to trigger common law vested right before the code changed. 1992, the owner did not do anything to trigger a vested right. Therefore, a common law vested right. It is not supported by statute. It is not supported by statute. In North Carolina General Statute 160D-108.1, statutory vested rights does not establish vested right on the statutory right. Of course, and is not supported by case law. As Mr. Murphy pointed out, there's not a case law on this because this is not the side that the government is generally on. So in my conclusion, since this owner does not have the vested right, he is subject to the current code, the buffer requirements in code section 12.302, which is a class A buffer with a 100 foot depth, and that would better serve the purpose of the code, the intent of the code, how the code was written in the first place. And I am 100% sure, that ordinances are not established to protect real estate investors, in this speculators. They are established just for the reason that the code says, that is to protect the health, the safety, and the general welfare of the public. Thank you.
Thank you, Mr. Gatewood. Thank you very much. Before we go into deliberation, does any of our board members have questions for Mr. Gatewood? Hearing none. Mr. Murray, do you have any questions for Mr. Gatewood? Okay. Hearing none. All right. If not, this concludes the presentation of evidence. The board will
Sorry,
now begin its
Mr.
deliberation.
Wilson, I just have to reiterate my objections, my speculation, objections on intent, personal opinions, materiality of those statements, but that's all I have. Thank you for your time.
Thank you. Noted. This concludes the presentation of evidence. The board will now begin its deliberations. Before we begin deliberations, board members, I know that some of you have to leave in the next 45, 50 minutes. Would you like to take a quick 5-minute break, or would you like to just go into deliberations right now?
I'm okay with deliberation.
Deliberations, okay. All right. Okay,
I'm
so we
okay
will
with
begin our
deliberations.
Okay, all right. So during this time, interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. So deliberations have begun. I will begin with the first board member I see on my screen is Mr. Floyd.
I don't think this is a close call. I appreciate the fact that Mr. Gatewood does not want a warehouse to be constructed behind his residence. I get that, but that's not really relevant. The fact that it might have some impact on his property value is not relevant. What the purpose of government is not relevant. This is an appeal of a determination by the zoning administrator that this property has vested rights. And that's what our question is. It is not a discretionary issue. It is not one where we get to say, well, is this consistent with the spirit and intent of the ordinance, the way we would in like a variance situation? It is purely, the case law says there are 4 things that must exist. And if those things exist, you have vested rights. That's it. Nothing else really matters. And so the question is, was there a valid government approval? Yes, I think undoubtedly there was. There were actually 2. There were one that occurred way back in 1990 when the entire tract was conditionally zoned. And then there was a second one, I think, when the new property owner purchased the property, or prior to purchasing the property, where they got confirmation on what the buffer would be. Did they reasonably rely upon the approval? Yes, they use that approval to develop the property, and initially, and the property owner used that approval in purchasing the property. Did they make substantial expenditures? Yes, I think the evidence is clear. They spent a lot of money developing this tract of land into a development, and the property owner, the current property owner, spent money to purchase it, to obtain engineering and architectural drawings and things, and spent hundreds of thousands of dollars. So that factor is met. And did they act in good faith? Yes. There's no evidence has been presented to indicate that the prior property owner at the time the initial common law vested rights occurred, or the new property owner knew anything that there was going to be a change, or there was any basis for them to believe that they did not have the rights that were established way back then, which would allow for a 30-foot buffer. I asked the question, Mr. Murray, put the case out there. Vested rights won't run with the land. It does not matter that you've got a change in ownership. And so if they were vested back in 1991, whenever the developer, 92 or whenever it was that the property started to be developed, they were vested then, and they continue through 2000 when another building was constructed, through now when the city is constructing something, and when the new owner wants to do something. Everything else is irrelevant. The only question for us is, was there evidence of those 4 things? And if we find that there was, which I believe there was, then the decision of Shad Spencer should be affirmed. And that's how I would vote. Thank you.
Thank you, Mr. Floyd. Ms. Long?
Well, I would agree with Mr. Floyd. I do want to say thank you to Mr. and Mrs. Gatewood for your patience, as I know that your appeal has been delayed, and I certainly can appreciate your situation. But I would vote to uphold the zoning administrative decision.
Thank you, Ms. Long. Ms. Dryden?
Deborah, I think you're on mute.
Yeah.
Is that better?
Yes.
Okay. There was a lot of discussion about these vested interests, the common law vested interest, and I'm looking at the period of validity for these vested interests, and it says for multiple phase development, and that's what these business parks are. They don't fit a time frame of 5 years or 10 years usually. And it also says the level of investment, which we know, as Mr. Floyd pointed out, the need for the development, and I guess in 1990 there was a need for this development. It accounts for economic cycles, which means that there may be periods of time when, and we did have some monetary difficulties during this period when people didn't invest in things, and also market conditions. So I think that I appreciate Mr. Gatewood's passion, but he's parsing hairs because he kept saying that the owners, and the vested rights follow the land. Doesn't matter if had one owner or 10 owners or 20 owners, until that project is finished and all those lots are sold, as long as they're during that period from 1990 today, there have been consistently developed parcels. There's 2 parcels left. This is one of them. So based on everything I've heard today, I believe that this land has common law vested rights, and I would vote to uphold the zoning ordinance as presented. Thank you.
Thank you, Mrs. Dryden. Mr. Williamson? I know that you're on the phone. You may have to unmute yourself. Marshall, are you still there? Terry, is Marshall still in the queue?
He is. Let me see if I can unmute him on my end.
Okay.
Okay, Marshall.
Can y'all hear me now? Can you hear
Yes,
me
we
now?
can hear you. Yeah, we can.
Okay. Yeah, I agree with everyone. The subdivision rights are vested and run with the land. I don't have any problem with voting to uphold that.
Okay, great. So my take on it is this. These cases are always hard when it comes before us. I'm very appreciative of the Gatewoods, of their presentation, their patience. We've delayed this appeal for at least 2 months now. Also very sensitive to the fact that they've been in that house for 30 years, and in their backyard they see this new development being built, and I know the growth of Charlotte is causing a lot of these new developments to come in particular in various parts of our city, in particular the west side and the east side and other areas. I'm very, very, very sensitive to that. But just given what we've been presented with, and I know this has always been, something that we have to do, we got to make our decisions based upon the finding facts of law that what we have presented to us. So I just want to make a note for the record of that. So I would go in agreement with my other board members, but again, definitely sensitive and understand where the Gatewoods are coming from, and I get they've been there for over 30 years, but we have to make our decisions based upon what the current law is saying, and so that's my take. All right. With that said, any other comments, thoughts from the board before we close out deliberations? Okay. All right, that concludes our deliberations. Now we will move into voting. Is there a motion on the floor?
Dryden, I
Oh,
make a,
John.
oh, go ahead.
I'm sorry, John, you were on mute.
Sorry, motion to uphold the decision of the zoning administrator.
Okay.
Dryden, I second that.
Okay, there was a motion made by Mr. Floyd to uphold the, make sure I have my thing here right, the zoning administrative decision, seconded by Mr. Dryden. Now we move into a period of voting. Ms. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Ms. Long,
Long, yes.
and Mr. Williamson.
Williamson, yes.
Okay. Mr. Wilson, Chair, yes. So that concludes the appeal. Thank you to our participants that presented in this case. I know it's been a long morning, and thank you very much.
We need to vote to approve the findings of fact and conclusions of
Yes.
law.
Yeah, I was just getting to that. I was getting to that. Now we will have a vote to approve the finding, facts, and conclusions of law. I don't believe, and board members, let me know if you feel this way, if we have to make any changes to the finding facts of law based upon the two presentations today. I don't think anything new was added into that, so I think that they are good to go.
No, pardon me? Were you speaking about us?
No, Mr. Gatewood, the deliberation is over. I'm speaking to the board members for the finding facts and conclusion of law.
All right, Dryden, I make a motion that we approve the finding of facts and conclusions of law as written.
Okay,
Seconded by
motion's
John
been-
Floyd.
Okay, motion to approve the finding facts and conclusions of law as written was moved by Ms. Dryden, seconded by Mr. Floyd. Now we move into a period of voting. Mr. Floyd,
Floyd, yes.
Ms. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Mr. Williamson.
Williamson, yes.
Okay, all right, Wilson, yes. Okay.
Hello?
That concludes.
Hello?
Yes, Mr. Gatewood, we have concluded your case.
Pardon me? You say you have
Said,
completed your case.
Oh, he's probably not talking. Terry, can you please mute that line? Thank you. All right. Okay, so board members, I know that it's been a long morning. So I know that some of you have to leave pretty soon. We still have some cases to go through that are on the agenda. Let's take a 5-10 minute break and we can come back. Is that okay with everybody?
That works.
All right. Let's go to 12:42 then.
Hey, Douglas, this is Marshall.
Yes.
I gotta step into 1 o'clock. I should be done at 3, so I will try to rejoin
Okay.
the meeting at that point. I don't know if that goes to our quorum.
Okay. All right. Great. Thanks. Okay, do we have everybody back? I think we do. Can everybody hear me okay? So make sure my AirPods connected. Okay, great. So I think this is what we should do, Terry. If we can run through the cases on the agenda that are not contested, I think we should try to knock those out as quickly as we can, and then see where we are once we get to the cases that are contested.
Agreed.
'Cause I would hate, yeah, because I would hate to rush applicants who want to be heard. So, yeah. Okay. So, is case number 202197 contested? Do you know if that one is, or how many do we have that? How many do we have that are not contested? I would say.
So 097 is contested,
Okay.
as well as 100.
Okay, so the rest, so only 2 are contested. All right, so I say let's just start with case number 2021-098. Oh, well, you already have it up, Lisa. I didn't realize that. Okay. All right, great. Lisa, I guess I have to swear you in again, even though you were sworn in this morning, right?
No, I'm already sworn in.
Okay. Okay, great. Okay, cool.
All right.
You can go ahead and.
Okay. Our first case is a 9.5-foot variance from the required 20-foot setback for a garage. And I'll give you a minute to look at your findings, and you can just let me know when you're ready.
Okay, you can proceed, Lisa.
Before you do, I forgot about this. We might want to
Yes.
go ahead and ask the applicants if they are okay going forward with the 4 board members rather than 5, just so we can have it on the record that we have a quorum, so we can do it, but if they're comfortable with that.
Okay, good point, Chad. Terry, can the applicants hear me?
Yes, sir. Mr. Ryan is now a
Yeah,
panelist.
yeah. Yes, Mr. Ryan, are you okay with the board going with 4 members at this time? In case we do get to 4, we're at 4 now, but are you okay with that? Mr. Ryan heard me. Terry, is he still there?
Yes, sir. Mr. Ryan Musin. He's unmuted on my end.
Okay, he may have stepped away. Since that's been put into the record by the court reporter, I think we can go ahead and proceed.
Okay, exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning is R5 single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The applicant obtained a permit in April to construct a detached garage facing Lorna Street. The typical street side yard along Lorna Street is 10 feet, and that was noted on the permit. But the code requires garages to be set back at least 20 feet from the back of the right-of-way or the back of the sidewalk, whichever is greater. The garage was constructed as shown on the permit plot plan, 10.5 feet from the back of the right-of-way, but it should have been at least 20 feet from the back of the right-of-way. After construction, the applicant was issued a notice of violation. So here you can see where the location of the sidewalk and the back of right-of-way is. So the garage is 19 feet from the back of the sidewalk and 10.5 feet from the back of the right-of-way. Exhibit number 6 is the variance request. The applicant is requesting a variance of 9.5 feet from the required 20-foot garage setback for compliance of the garage. Exhibit number 7 is considerations. The hardship was not a result of actions taken by the applicant. The permit issued for the garage specified that the setback was 10 feet and the garage was constructed exactly as shown on the applicant's plot plan. The applicant states they were unaware of the 20-foot setback required for garages until they received the notice of violation. The hardship results from conditions peculiar to the property because this is an older neighborhood and the sidewalk is actually located 8.5 feet from the right-of-way and directly abuts the paved portion of street. This may have caused confusion with permitting because the back of sidewalk typically abuts the back of the right-of-way in newer subdivisions. Although the distance of the garage to the right-of-way is 10.5 feet, the distance of the garage to the back of the sidewalk is 19 feet, and the distance to the back of curb is 23 feet. The variance is in keeping with the intent of the zoning ordinance and upholds public safety. Driveways and parking pads are required to be a minimum length of 20 feet for single-family homes, and that accommodates parking and maneuvering area, ensuring vehicles aren't parked on those sidewalks or yards, and allows visibility and pedestrian safety. Because of the increased distance between the back of the right-of-way and the back of the curb, there's room to accommodate a driveway that is 19 feet from the back of the sidewalk, and that meets the intent of the zoning standards. Exhibit number 8 is photos of the property. So the first picture over to your left is a photo of the front of the property, and to the right is a photo of the garage. And that's the end of my presentation, and just let me know if you have any questions.
Thank you, Lisa. Are there any questions for Lisa from the board? Okay. Hearing none, is there a motion on the floor to approve or deny the variance?
Dryden, I make a motion to approve the variance.
Motion been approved. A motion been made to approve the variance by Ms. Dryden. Is there a second?
Long seconds.
Okay. There's been a second by Long. Now we go into period of voting. Ms. Long,
Long, yes.
Mrs. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
and I don't know if Mr. Williamson already dropped off, but I'll ask.
Yes.
Okay, Ms. Williams, yes. Okay, Wilson, yes. Okay, the variance has been approved. Now we go to findings and facts of law. Is there a motion to approve the finding and facts of law as presented?
I make a motion to approve the finding of facts as presented.
Okay, motion's been moved to approve the finding and facts of law as presented by Mrs. Dryden. Is there a second?
Long seconds.
It's been seconded by Ms. Long. Now I go into period of voting. Ms. Long,
Long, yes.
Ms. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Mr. Williamson. He's still there? Okay. Not Wilson, yes. Okay. That concludes case number 2021-98. Our next case, if I'm following the agenda, there it is, 2021-099. Okay, Terry, do we have any applicants on the line for this case?
The applicant is on. I'm just trying to determine which call-in user they are.
Okay.
Give me 1 second.
Okay.
This is Jonathan Hamlin. Can you all hear me?
Yes, Mr. Hamlin, we can hear you. Just want to ask,
Thank you.
we are currently we currently have 4 out of our 5 board members, and we want to just ask, are you okay with us moving forward with your case with 4 board members?
Yes, I am. Thank you.
All right, thank you very much. Okay, Lisa, you can proceed.
Okay, the next case is a residential setback variance. They're requesting a 23-foot variance from the required 30-foot setback to construct a pool and a cabana. And I'll give you a minute to read over your findings.
Okay, Lisa, you can proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map of the property. The property is zoned R3, single family. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 2003, and there's a home on the property built in 2004. The functional rear yard of the property abuts Wendover Road, and there's a 30-foot setback. Exhibit number 6 is more background. A pool permit was issued in August for the property, noting a 3-foot rear yard, and that's the typical rear yard for an accessory structure. However, there's a 30-foot setback from Wendover Road, and the code doesn't permit accessory structures in a setback. The applicant's rear yard was graded in preparation for the pool. The error in the permit was discovered in September when the applicant applied for a permit for a cabana adjacent to the pool. So the pictures below are showing the rear yard before and after the preparation for the pool. Exhibit number 7 is the variance request. The applicant would like to construct a pool 8.1 feet and a cabana 9.5 feet from the rear property line. So they're requesting a variance of 23 feet from the required 30-foot setback. And you can see a survey showing the rear property line and where the current home is, and also where the proposed cabana and pool will be located. Slide 8 is considerations. Staff supports the requested variance. The hardship's not a result of actions taken by the applicant. The applicant states they were unaware of the 30-foot setback requirement. The hardship results from conditions peculiar to the property. At the time the plat was recorded in 2003, 10 additional feet of right-of-way were dedicated to Wendover Road. The permitted building area for accessory structures is decreased for this property because of the setback along Wendover Road. Without the setback, an accessory structure would be permitted up to 3 feet from the rear property line. The 30-foot setback covers most of the functional rear yard, and it would be difficult to locate an accessory structure within the compliant building footprint. The property ranges in depth from approximately 128 to 134 feet, and that's less than surrounding properties that have depths of about 200 feet. And you can see that in the graphic over to the right that calls out the side yard dimensions. Exhibit number 9 is considerations. Granting the variance will not change the character of the area because the encroachment will not be easy to detect. There's screening by a fence and vegetation along Wendover Road, and the applicant states that they will provide additional plantings. They've also provided a planting plan with their variance application, and the planting plan is shown on the screen. Granting the variance will not impact public safety. Exhibit 10 is a photo of the fence and vegetation screening the property from Wendover Road. And Exhibit 11 is a photo of the subject property. And that's the end of my presentation. If you have any questions for me.
Thank you, Lisa. Does the board have any questions for Lisa?
Lisa, can you go back to that prior picture that showed from the street? So is that picture taken before or after the backyard had already been graded for the pool?
This would have been before because this is a Google Street View.
Okay. Do we know what it looks like now?
I'm not sure because there wasn't any space to park, and I'm not sure which one was the home on that side.
Okay.
Okay. Any other questions? Okay. All right. Hearing none, is there a motion to approve or deny the variance?
This is Dryden. I make a motion to approve this.
Motion has been moved to approve the variance by Ms. Dryden. Is there a second?
Second by John Floyd.
A motion's been seconded by Mr. Floyd. Now we move into the period of voting. Mr. Floyd,
Floyd, yes.
Ms. Dryden,
Dryden, yes.
and Ms. Long,
Long, yes.
and Wilson, yes. Okay. Now we move to this the staff finding and conclusion. Sorry, the findings of fact and conclusion of law. And I didn't see anything need to be changed. Is there a motion to approve the finding facts and conclusions of law as stated?
Motion to approve the findings of fact and conclusions of law.
Dryden,
motion has-
second.
A motion has been moved by Mr. Floyd to approve the finding and facts and conclusions of law, seconded by Ms. Dryden. Now we move into voting. Ms. Dryden,
Dryden, yes.
Mr. Floyd,
Floyd, yes.
Ms. Long,
Long, yes.
Mr. Wilson, yes. Okay. All right, that concludes that case. We're ready for our next case. All right, next case is 2021-102. Terry, is the applicant on the line?
Yes, sir. Mr. David Murray is here representing.
Representing. Okay. Mr. Murray, are you okay with the board going forward with 4 members?
Yes, sir, Mr. Chairman. We consent to that.
Okay, great. All right, Lisa, you may proceed.
The next case is a residential rear yard variance request. The applicant is requesting a 4-foot variance from the required 40-foot rear yard for compliance of an existing home. And I'll give you a minute to look at your findings.
Okay, Lisa, you may proceed.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned R4 single family and is located in the Dilworth Historic District. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 1939, and the home on the property was built in 1942, and this was prior to zoning ordinance regulation. Exhibit number 6 is the variance request. The applicants wish to sell the property, and a survey commissioned for the sale shows that the rear of the home encroaches about 3.17 feet into the 40-foot rear yard. The applicants believe the encroachment dates back to 1986, when a contractor was hired to enclose the garage. Current rear yard regulations existed in 1986, so the encroachment would not be non-conforming. The applicants are requesting a 4-foot variance from the rear yard to bring the home into compliance. Staff supports the requested variance, and exhibit number 7 is considerations. The hardship was not a result of actions taken by the applicants. The applicants state all necessary permits were obtained through an independent contractor to enclose the garage, and they were not aware of the required 40-foot rear yard prior to the survey. The hardship results from conditions that are peculiar to the property. The survey shows an established setback of 37 feet in the front, which is 7 feet greater than the required 30-foot setback for the district, and that narrows the permitted building depth. The rear yard of the subject property is slanted, creating a lot depth ranging from 124 to 137 feet, and that's less than the average of other lots on the block. Unnecessary hardships result from strict application of the ordinance. The lot was subdivided in 1939 and the home was built in 1942 prior to zoning ordinance requirements. The variance will not adversely affect adjacent or contiguous properties or change the essential character of the neighborhood. The home has existed in its current configuration for 35 years. The encroachment is not easy to detect and the footprint of the home will remain the same. Exhibit number 8 is a photo of the subject property, and that's the end of my presentation. Please let me know if you have any questions for me.
Okay, great. Thank you, Lisa. Are there any questions for Lisa from the board? Okay. And hearing none, Mr. Murray, do you have a presentation to provide?
No, sir, as there's no objections on the recommendation agenda, we're going with staff's presentation. Thank you.
Okay, thank you very much. Okay. Is there a motion on the floor to approve or deny the variance?
Motion to approve the variance.
Second.
Okay, motion. All right. Motion to approve the variance was by Mr. Floyd, second by Ms. Long. Now we move to period of voting. Ms. Long?
Long, yes.
And Mr. Floyd?
Floyd, yes.
Ms. Dryden?
Dryden, yes.
Okay, and Wilson, yes. Okay, the variance has been approved. Now we go to the finding facts and conclusions of law. Did anybody see any changes that need to be made? Okay. Okay. Hearing none, is there a motion to approve the finding and facts and conclusions of law as stated?
Motion to approve the findings of fact and conclusions of law.
Okay. Motion to approve the findings and facts and conclusions of law was made by Mr. Floyd. Is there a second?
Dryden, second.
Okay, second by Ms. Dryden. Now I move into period of voting. Ms. Dryden?
Dryden, yes.
Ms. Long?
Long, yes.
Mr. Floyd?
Floyd, yes.
And Wilson, yes. Okay. That concludes that case. Okay. Oh. Okay, our next case is 2021-104. Terry, is the applicant on the line?
Yes, sir. Carrie Colson has been made a panelist.
Yes, I'm here. Can you hear me?
Yes, Ms. Colson, we can hear you. Good afternoon. Are you okay with your case being presented to 4 board members? We usually have 5, but we have 4 today.
Yep, sounds good.
Okay, all right, great. Okay, Lisa.
All right, this is a residential side yard variance request. The applicant is requesting a 4-foot 3-inch variance from the required 5-foot side yard, and I'll give you a minute to look at your findings.
You may proceed.
All right, exhibit number 1 is a vicinity map. Exhibit number 2 is a zoning map. The property is zoned R5 single family and is located in the Wilmore Historic District. Exhibit number 3 is an aerial map. And exhibit 4 is a close-up aerial map. Exhibit number 5 is background. The property was subdivided in 1914 and the home on the property was constructed in 1933. The home is non-conforming because it predates the ordinance and does not meet the required 5-foot side yard. There's an established right side yard of approximately 0.6 feet. Exhibit number 6 is the variance request. The access to the crawl space and hot water heater under the home is located on the rear of the home in the encroachment area. The applicant wishes to provide a formal access to the crawl space door with decking and steps. The applicant is requesting a variance of 4 feet and 3 inches from the 5-foot side yard to construct the access. You can see the proposed site plan on the right that does not exceed the established side yard. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship does not result from actions taken by the applicant because there's an established side yard of approximately 0.6 feet, and that dates back to 1933. The hardship results from conditions peculiar to the property. The property is a corner lot, which imposes a greater street side yard and narrows the permitted building width. Granting the variance will not alter the essential character of the neighborhood. It won't exceed the established side yard. The applicant states that the portion of the existing home that encroaches into the required side yard is the only access to the crawl space under the home. Granting the variance to construct a formal access to the crawl space will allow the new access to be visually integrated with the existing side of the home. Granting the variance is consistent with the spirit and intent of the zoning ordinance, and if granted, the proposed improvements will require Historic District Commission approval. Granting the variance will not adversely affect adjacent or contiguous properties. The proposed encroachment does not exceed the established side yard that has existed for 88 years and will not be easy to detect. The applicant's proposed plan shows new shrubs along the right side of the property to provide screening. Granting the variance will ensure public safety, and the applicant states that the variance will allow safer access to the crawl space and hot water heater for maintenance. Exhibit 8 is a photo of the crawl space door on the rear of the property. Exhibit 9 is a photo of the front of the home. And that's the end of my presentation. Please let me know if you have any questions for me.
Thank you, Lisa. Do any of the board members have any questions for Lisa? Okay. And
wait, I want to
I'm
see
sorry.
that last slide again, where the crawl space is. Please. Okay, so what do they want to do? They're going to extend the, how are they going to fix that? Are they going to put steps there? Extend the steps?
They're going to put a deck around the back and then steps down to the access.
Oh, okay. Gotcha. All right. Thank you.
Thank you, Ms. Dryden. And I failed to do this in the previous case when an applicant was on the line, but Ms. Colson, do you have any questions for staff based upon Lisa's presentation?
No, I don't. I think she stated it well.
Okay. All right, great. Thank you. Okay. Is there a motion?
Yeah, I make a motion to approve this variance.
Okay. Motion's been made to approve the variance by Mrs. Dryden. Is there a second?
Long seconds.
Okay. Motion's been seconded by Ms. Long. Now moving to a period of voting. Ms. Long?
Long, yes.
Ms. Dryden?
Dryden, yes.
Mr. Floyd?
Floyd, yes.
Okay. And Wilson, yes. Okay, the variance has been approved. Now going to the finding facts and conclusions of law. Do any board members see anything need to be changed?
Dryden, I make a motion to approve the finding of facts and conclusions of law as stated.
What up, Will? How's it going, man?
Okay, there's been a motion to
for sure. That
Terry,
Not
can you,
really, but then when
Terry, can you mute that line, please?
I don't know, when it's getting doing this call, it's like, man, that's some serious stuff. But I was like, man, this is probably super unlikely. When they started giving the finding or their decisions.
Terry.
Okay.
You got it. Okay. Thank you. Okay. Yeah, I lost my train of thought there. All right. So.
Dryden, I made a motion to approve
okay.
the finding of facts and
In long seconds.
long seconds.
Okay. So, all right. So now, so Ms. Dryden made a motion to approve the finding of facts inclusive law. Ms. Long seconded it. Now I move to period of voting. Ms. Dryden?
Dryden, yes.
Okay. Ms. Long?
Long, yes.
Okay. Mr. Floyd?
Floyd, yes.
Okay. Mr. Wilson, yes. All right. Guess we know how folks feel about the process here, but all right. So moving on to our next case, Terry and Lisa, did that conclude all our non-contested cases? Do we have one more? I was trying to keep track.
That is correct. That'll conclude our non-contested cases.
Okay. All right. Great. Okay. So I think we're making pretty good time here. So now we can move to the contested ones, unless the board members need another break. If not, we can just try to just keep going. I see John scratching.
I'm good to keep going.
Okay. All right, we'll keep going. All right. Okay, Lisa. Let's go to the next one.
Now, Mr. Wilson, now I will say we had, so there are 3 cases left.
Mm-hmm.
Of those 3, 2 of them, there's staff support, but there is opposition. Okay. And that's case 2021-79, 97 and 2021-100. Those 2 are recommended by staff, but have opposition. The other case, 2021-96, is one where we're not at that point yet of supporting. If that helps with how you want to continue.
So 96 staff is approving, but there's some opposition to that?
96, we are not currently in support, but 97 and 100 staff is in support, but those 2 do have opposition.
Okay.
And Chair Wilson, if I might, my name is Colin McGrath. I'm the attorney for CLT Equities in case 96. We would prefer this one to be heard, if possible, by a full slate of board members. So we would just ask that this be deferred, I guess, until the next meeting.
Okay, thank you. That's very helpful. Okay, great. So Terry, I guess for the record, we can then Terry and Jill, just correct me if I'm wrong, if I am doing this incorrectly. Can we just go ahead and move that to our November meeting? Which, if we do have a November, I don't know if that falls around Thanksgiving, but whenever the next meeting is, just based upon what Mr. McGrath just told us.
Yes, that's been your practice, is even though 4 members is a quorum, you give the applicant the discretion to defer or continue until a 5-member board is present. And so that will be, I think that I'll defer to Chad and Lisa, but I think that the November and December meeting are combined. We do an early December meeting.
Well, that is a discussion we were going to have this afternoon, because the whole issue of having in-person hearings, that is something that the city manager's office and the city manager has requested that certain boards start back in-person hearings, which then would bring forth several cases that are backlogged because we don't have consent for virtual hearings. So I'm not sure, this is something we have to discuss, but I'm not sure if this is if we'll be able to cancel one of them, because we're gonna have a lot of cases pretty soon if we start back in-person hearings.
Okay.
Okay, so
Alright.
you may just want to say until the next meeting.
Yeah. Okay. Do we have to take a vote on that? Okay, I can just want to say this, we can move this case to next meeting, right?
I believe that once you ask the applicant and unless a board member objects, then you would just grant that request.
Okay, great. All right, if no board members object, I would like to grant the request of the applicant to move their case to the next meeting. This case is for, we can see it right in front of me, 2021-096. Okay, hearing no objections, that case will be moved to the next meeting. Thank you, Mr.
Thank you,
McGrath,
Mr.
for
Chair.
letting us know.
Thank
You're
you.
welcome. Okay. All right, so let's then go to our next case, and that would be, I think we decided to go to the ones that were, the one that was contested. So let's go to that case.
Okay.
So currently I do have in attendance opposition for case 2021-097.
And so would both the applicant and the opposing party both have to agree for this to be heard by 4 members of the board for it to move forward?
So I'll jump in on that. So,
I can't really hear you.
You sound choppy, Jill.
I know.
You sound kind of choppy.
You hear me?
Nah, it's kind of low and choppy still.
I'll try to get closer. Is that any better?
You sound like you're talking through like one of those computer things. Yeah.
Yeah, let me take a time out.
Okay. All right. So John, if I remember from past, I think we did, if I'm not mistaken. So I just think for just to be safe, let's just ask both the applicant and the party that is in opposition if they're okay with that. So Terry, just let me know once both the applicant and the opposition is on our panels, and I can ask if they are okay with us moving forward.
Okay, the opposition, Satish Babu, is currently listed as a panelist. I'm trying to locate the applicant as well, Jairus Tony.
I think Brian Rosenfeld is.
And Brian Rosenfeld look like it'll be the applicant representation.
Okay, so Mr. Rosenfield and Mr. Babu, here's what we currently have. We usually have 5 board members, but today we have 4. It is our duty to ask you if you are okay with us moving forward with your case with just 4 board members today.
Yes, we're okay with that.
Okay, is that Mr. Rosenfield?
Yes, this is Mr. Rosenfeld.
Okay. Satish?
Somebody unmuted me. Thank you. I'm
Okay.
good.
Okay, great. All right, great. Okay, Lisa, you may proceed.
There should be one more person here, my next door neighbor. Amy.
Okay.
Talbot.
Can you mute him? All right, the next case is a residential rear yard and setback variance. The applicant is requesting 2 variances to construct a single-family home, 15 feet from the setback and 25 feet from the rear yard. And I'll give you a minute to look over your findings.
Okay, Lisa, you may.
Okay, exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is a zoning map. The zoning is R3 single family. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property is a portion of a lot subdivided in 1955, and it's been in its current configuration since at least 1989, according to historic zoning maps. The lot is a non-conforming vacant lot since it is 9,151 square feet and doesn't meet today's minimum lot area requirement of 10,000 square feet. The code permits the lot to be used for single-family home if the dimensional requirements, including the setback and rear yard, are met. Exhibit number 6 is the variance request. When today's setback and rear yard are imposed on the property, there is an adequate area to build a home. Exhibit number 7 is background. The applicant is requesting a 15-foot variance from the 30-foot setback and a 25-foot variance from the 45-foot rear yard to construct a single-family home on the property. And you can see the difference on the left-hand side without a variance versus with the variance on the right-hand side. Exhibit number 8 is considerations. Staff supports the requested variance. The hardship did not result from actions taken by the applicant. The applicant states they were gifted the property without prior knowledge of the constraints. The hardship results from conditions that are peculiar to the property because there's a drainage ditch for the subdivision located on the right side of the property, preventing construction in that area. The lot is an inverted U shape, with the smallest depth of the lot being 67 feet on the right side, and imposing the 45-foot rear yard and 30-foot setback in that area results in an overlap of 8 feet and no permitted building depth. You can see the narrow lot depth on the aerial photo of the property. The non-conforming vacant lot is approximately 9,151 square feet, which is smaller in size than other lots in the area, with most lots over a half an acre in size. The subject variance request would result in a building depth ranging from 78 feet to 32 feet, which is consistent with other homes in the area, most homes having a depth of 35 feet or greater. Exhibit number 9 is further considerations. Granting the variance will not alter the essential character of the area. You can see how the requested building envelope will align with the neighboring homes in the area on the right and left. The applicant has provided an elevation of the proposed home as well. Granting the variance will not adversely affect adjacent or contiguous properties. And granting the variance request is in keeping with the intent of the zoning ordinance and would uphold public safety. The applicant's engineer has verified that they can accommodate a 20-foot driveway within the requested building footprint. Exhibit number 10 is a photo of the property, and that's the end of my questions. If that's the end of my presentation, if you have any questions for me.
Okay, thank you, Lisa. Does the board have any questions for staff, Lisa? Okay. Hearing none. Now, I know that we have the applicant on and we also have opposition on. So, Mr. Rosenfeld, I believe you're the applicant. Do you have any questions for Lisa based on her presentation?
No, I do not have any questions for Lisa. I know there was some questions that have come up regarding the drainage ditch associated on the plot. That will remain in place or it will be rerouted to be closer.
I think he needs to be sworn in.
Before, yeah, I was just about to get there, John. Before you continue, I need to swear you in. So, Mr. Brian Rosenfeld, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay, great.
So regarding the drainage ditch that's traveling through the property, that will be either extended towards the right of way. Most likely it'll just remain in place untouched for the build, with the building being on the plan west of the site. So I just wanted to make that apparent.
Okay, great. Board members, do you have any questions for Mr. Rosenfeld?
I would ask him to state his name and his address for purposes of the record.
Yes, Brian Rosenfeld with Blue Rose Engineering. Address is 14029 Lawther Road, Huntersville, North Carolina, 28078.
Okay, great. Thank you. Thank you, Mr. Floyd. Okay, hearing no questions for Mr. Rosenfeld, now we will go to Mr. Satish. Are you on? Okay.
Yes, sir.
I will have to swear you in. So if you can state your name, address.
Chair, real quick, I believe there's two neighbors that oppose on the same line. I believe there's an Amy on there as well.
Okay, let me go ahead and swear them in at the same time if that's possible, city attorneys. Can I do that? Yes, okay. So let's go ahead. So Mr. Satish, I'm going to swear you in first, and then the other neighbor, and then we can go from here. So Mr. Satish, can you present your full name and address?
Name is Satish Babu. Address is 226 Shenandoah Circle, Charlotte, 28215.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
Yes, I do.
Okay, and Terry, who was the next individual? I'm sorry.
Amy Talblue.
Okay, Ms. Tablu, can you state your full name and address? Ms. Tablu, are you there? Can you hear me? Okay. All right. So I tell you what, let's if it's possible, since I've sworn in Mr. Satish, if he can go ahead and give his presentation. If Miss Amy decides to, if she wants to come on, I'll just have to swear her in later. So let's just go with that. So, Mr. Satish, do you have any do you have a presentation to give? Did you submit that to the staff, or are you just going to give like an oral
Just
rebuttal?
oral. It's an oral.
Okay.
I don't have any position. I'm going to use the same documents which you guys are showing right now.
Okay.
Our
I'm sorry,
main
excuse-
concerns are, sorry.
Our court reporter can't hear. I don't know if there's something wrong with his speaker, or if he could just slow down, maybe that would help.
Okay. Okay.
Okay.
I'll use the same presentation which is on the screen. And our concerns are about the stormwater runway which feeds the pond, and we have to make sure that's proper, because right now when it rains heavily, that property floods.
Mr. Satish, are you able to take yourself off speakerphone?
Yes, sir. One sec. Okay.
Yeah, and our apologies, Mr. Satish. We have a court reporter that's trying to dictate what you're saying, so we want to make sure that's correct for the record.
Okay, can you guys hear me now? Better?
Yes, that's better.
Okay. So our major concerns are about the stormwater drain, which feeds the pond, which is a 3-acre pond. And usually when it rains, it floods that area. And it's a good sized ditch. And if it's built, I want to make sure there's a better option than what we have currently. And so that the water flows proper. We don't want any obstruction to the pond water. That's a major concern. And the other concern is the front 15-foot variance instead of 30-foot. Since it's in a curve, when they build a house, we were thinking it's going to kind of a big monolithic ugly one, which is not going to conform with the other houses in the neighborhood. The whole neighborhood is a brick ranch style houses, and there's already 3 houses which are built not similar to what we have right now, and it's already um, deviated from what it looks like. And this building being built right close to the curve and not to the same structure as the other houses. If it's a little bit further back, it'll be good, but we don't like that 15-foot variance there. And the main thing is about that water being fed from Robinson Church Road, all the way the water floods that particular property and then drains in the pond. And that road, on a heavy rain, it has almost like 6 inches to 10 inches of rain. If something's going to be built, the city should take a look at the actual plan. They should make it better to drain that before they allow something to be built. That's all I be asked for.
Okay, thank you, Satish. Terry, and I hate to call folks by their first name in this setting, but I can't remember Amy's last name. But is Amy on? Do you know if she got on?
No, sir, she's out.
Okay, all right. Board members, do you have any questions for Satish based upon his oral arguments? All right. So, hearing none, then this will conclude the presentation of evidence. So now the board will begin its
Actually, Mr.
deliberation.
Wilson, can I ask a
Yes.
question of the applicant?
Sure.
I guess I just want to know what his response is to the concerns of Mr. Satish about the water and, how that is going to be addressed.
Yeah.
I mean, it looks like the construction is going to be on the other side of the property. It shouldn't, impact the drainage ditch, but I'd just like to know what the applicant has to say about it.
Yeah, definitely. The lot will definitely be graded a little bit more gradual to be conducive to a building to be placed there. I would anticipate some of that grading for that ditch would be better defined because I don't believe it's been touched in the last 30 or 40 years. It's probably overgrown at this point, which might be causing some of the drainage issues, maybe clogging of the storm drain and that kind of issue. So that area would most likely be cleaned up with someone actually building and developing this lot. Rock would most likely be placed within that drainage ditch to control some of the drainage that's flowing through the lot, to make it a little bit cleaner and better for future. But related to his concerns, the placement of the building obviously isn't going to disturb that ditch. The side yards are being maintained, meeting the requirements of the ordinance. It's basically just placing the building on plan west of the site and not really disturbing that existing condition that's out there today.
Thank you, and thank you, Mr. Floyd, for catching that. My apologies. Do any of the board members have questions for the applicant or for Mr. Satish? Okay. Does the board have any other questions for staff? Okay.
I have a question for Mr. Rosenfeld.
Yes.
Okay.
When you answered Mr. Floyd's question, you said should, could, would, probably. Are you not the engineering company that's going to do this?
I am the site designer on the site.
So tell me then what you are committing to do for this drainage ditch.
Yeah, so we're
Not should, could, and would, but what do you commit
Right.
to do for this draining ditch?
Yeah, so we're planning on cleaning up that area when the lot will be graded. Some of the overgrown vegetation will be removed. The sediment buildup that occurred over there will be cleaned out. And that drainage ditch will just be better defined than what it is today. Right now, it's 30, 40 years of overgrowth and basically sediment discharge from upstream that just is most likely hurting the condition of that ditch and of the pipe that enters the pond. So that area will be cleaned up, with someone actually coming in, owning the home, maintaining the home, and that land, as opposed to it just going vacant and sitting.
Sorry to interject here. It's not a small ditch. It flows water in massive amounts. It's from whole Robinson Church Road, like 3 or 4 houses. Surface water from that all goes through this lot. And it's not a small ditch which a homeowner will be able to maintain. It should be able to be maintained by a city with a bigger, that is my concern. It's not a small stream of water. It's heavy flow of water coming into the pond. The stones and all those things are already there.
Okay.
Mr. Satish, have you approached or contacted the city or the neighbors about this stormwater drain?
Yes, ma'am. Not personally, but my neighbor did that like 5 years back or something. And city said that's not their responsibility. And there is foot of water going through the road, crossing the road, and she was not able to get out of her car. And she stated that in her email to Terry.
Okay.
All right. So,
I'm sorry, Ms. Wilson.
Yep, thank you. So with the development of this land, it should control and manage this ditch a little bit better. I've seen some of the pictures and I've been out on site, and it is overgrown in that ditch. I believe just cleaning it up and maintaining it. As mentioned, the city does not maintain drainage ditches that are in private right of way. So that would be the responsibility of the homeowner to maintain that and control that how they need to. And there'd be more incentive with, their home being on the property being developed, as opposed to just going vacant and unmanaged.
So my other concern is it's not the development company you represent or engineering company which is going to maintain that. It's the property owner, and we don't know who is going to be that, and we won't have a guarantee of whether it will be maintained. It's a 3-acre pond, and we bought the property just because it's right in front of the pond. And if that's not maintained, they just built a house next to it. While building it, I had to call code enforcement because the fishes were kind of dying. It was that bad. So what guarantee can I get when a building is being built there that I won't have any issues? Since you're not the one who's going to maintain it. That is my concern.
Right. Well, with the building permit, definitely the required erosion control measures are going to be implemented on the site during construction, which would be most likely a stabilized construction entrance, which is stone, so that minimizes runoff into the pond. Silt fence is required to be placed around the property. So any drainage or sediment that's coming off of the property, it's controlled and not going directly into the pond. And some of the grading and clearing of that area would be one of the first things that occurs with the construction of the home. So if there was any repairs or anything that needs to happen to that ditch, that would occur prior to the construction of the home or the beginning of the construction of the actual structure, to prevent any issues down the line through construction.
I have a question.
Go ahead, sir.
I have a question for you, Mr. Satish. How often is this part of the property flooding? Does it flood every time it rains?
Heavy floods, heavy rains, heavy rain.
Right. So that would most likely be, I'm assuming, 25-year storms, 10-year storms, that kind of thing.
5 years, because it happened 5 years back. So that's all I can go back to.
5 years ago.
Mm-hmm.
Okay.
If city can guarantee that water won't be an issue, and then I can have some kind of return in the permit that they're allowed to maintain it, they should maintain it in a certain way, then I don't have an issue people building a house there. I don't have to fight for every time it clogs up or some sediment comes into the pond, and I have to go and ask the property owner to fix it. It doesn't make sense for me.
And Mr. Rosenfeld, if I heard you correctly, you feel, to the best of your knowledge, that the flooding can be controlled by cleaning up, this vegetation that's there, that's been there for over 30 or 40 years, and just trying to put some rock settlement there as well?
That's correct. Put some cleaning up the vegetation, maintaining and reshaping that ditch, placing riprap in to slow down the velocity of the water to avoid erosion in that area. Simple things like that go a long way with controlling floodwaters and controlling the water that's coming from the offsite areas.
I want to make a statement there. There are almost like 2-foot rocks put in there for that particular reason. It's there.
Mr. Rosenfeld, do you have a response to that?
Yeah, just from seeing the site, the vegetation is overgrown. The rocks are there to slow down the erosion. But the overbrush that's in that area is causing some effect. And I know with someone actually owning that land and building a structure on there and living there, it would be better maintained than it is currently, and better for the overall community. They'd have more buy-in, than the site just going vacant.
Okay. We're running up against the time for deliberations, the time for the presentations between the applicant and the opposition. Just want to make sure, Mr. Rosenfeld and Mr. Satish, do you have any closing remarks to make?
From my side, as long as it's returned and then structural engineer looks at all from the city side, not from the developer side, from the city, make sure the water, the pond department, I don't know the exact terms, who are responsible for the ponds in the city, can take a look and make sure that's proper. It'll be good.
Okay.
Before we can approve it.
Yeah, the only thing that I would have to say is, the side yards are being maintained with the adjacent owners. This really just affects the setbacks and rear yards. This structure being placed on the site is not going to adversely affect that existing ditch that's on site. It would only make it better with the homeowner actually being on site, living there, and maintaining it themselves. So the variance request would not affect that ditch or the stormwater, would only make it better.
And that is an assumption.
Okay. All right. Before we move to deliberations, again, board members, do you have any last minute questions that you want to ask? Okay, hearing none. This concludes the presentation of evidence. The board will now begin its deliberations. Just a reminder, the interested parties are not permitted to address the board during this portion of today's meeting. However, you are permitted to remain present and listen quietly to the board's discussion and vote. So now we are on deliberations. I would start with the first board member I see on my screen is Mr. Floyd.
Thanks, Mr. Wilson. I always on these cases try to look at the four things that we're supposed to consider. Whether there's an unnecessary hardship. I think given the shape of this lot and what the setback requirements are, I mean, looking at that picture that's there right now with the little tiny triangle, seems like you wouldn't actually be able to build on this lot if you were to impose the actual rear yard and setback requirements. So I do think there's an unnecessary hardship. It appears to, result from conditions peculiar to the property. That's an oddly shaped property that's not very large, and so you put those conditions on it, and again, you just can't build. Nothing the applicant has done, has caused that. It just is what it is. It's an odd lot that they were deeded. And then the question about, whether it's consistent with the spirit and intent of the zoning ordinance. I think allowing changes to the setback requirement and the rear yard requirement, given the testimony of Lisa and, what that looks like in comparison to the other homes in the area, I think is consistent with those things. I would probably vote to approve the variance. The one thing I'll add is, although I asked the questions about the ditch and I understand the concerns, I don't think that's something that the ZBA is responsible for dealing with or even empowered to deal with. But I do think that, common sense would tell me that having a homeowner on that property that's going to be interested in making sure that his own property does not get flooded by stormwater is going to be a better solution than just having the lot vacant and overgrown. And so hopefully, getting somebody in there would actually alleviate some of the issues that the neighboring residents face. So with that, like I said, I'll probably vote to approve the variance.
Thank you, Mr. Floyd. Ms. Dryden?
I agree with Mr. Floyd. I appreciate, and I did ask some questions about the drainage, but really that's not something that we're supposed to consider. We can't, that's peculiar to the property. That's not the homeowner's fault. I would hope that if we vote for this and it goes forward, that Mr. Rosenfeld, you take into account the concerns of the neighborhood, and aesthetically, we have no control over that, but to be aware of the other houses in the neighborhood and help this build be as conforming as possible to the other homes in the neighborhood and not something that stands out. That would just be my suggestion and my recommendation. But I'm inclined to vote for this because it does meet all of our criteria. And I would rather see a house on this property than to see it just vacant and overgrown.
Thank you, Ms. Dryden. Ms. Long?
I would agree with my fellow members. I don't have anything to add to what they've said. I'm inclined to vote to approve.
Okay. And for me, I agree. Same thing here. I agree with all the rest of the board members, and I would vote to approve this variance. Okay. So that concludes our deliberation on this case. Is there a motion to approve the variance? I know
Make
Mr.
a
Floyd
motion
is
to
on mute,
approve.
but I can tell. I'm sorry, I think Mr. Floyd, okay, my bad.
And I'll
All right, so
second.
Ms. Long, okay, I'll go
Sorry.
Ms. Long. That's fine. All right, Ms. Long, Ms. Long made a motion to approve the variance. It was seconded by Ms. Dryden. Now we're moving to period of voting. Ms. Dryden,
Dryden, yes.
Okay, Ms. Long
Long, yes.
and Mr. Floyd?
Floyd, yes.
Okay, Wilson, yes. Okay. Now we go to the finding, facts, and conclusions of law. Only question I had here, and I presented to the board, do we need to add an additional spot that says that the applicant will provide some type of structure to control the flooding, or is that something that we can't add? Just a question.
I would refer to our council, but I don't think we have the authority to place that kind of condition on it, but I could be wrong.
Yeah, that's what I was thinking too. City attorneys, do we have that authority?
Can you hear me now?
Jill still has the computer voice going. Can't make her out. Yeah. Terry, do you have a?
What was the specific condition you were asking about, Mr. Chair?
So during the presentation, the applicant said that, to control the flooding, that they will go in and clean out the vegetation and put down rock settlement to control the flooding. And I know that we know the flooding was a concern of the opposition. And so I don't know if we should put in the finding, facts, and conclusion of law that the applicant said that he would do that. And I mean, it's just a question. I don't think we can, but I just wanted to make sure.
Well, yeah, I believe that you can add pertinent conditions as a board if you believe that it's relevant to your granting of the variance. So is it something that you feel that's relevant to the variance?
Well, based upon the majority of the board, it seems like the variance was granted based upon the fact that there wasn't any unnecessary hardship, if I'm correct, board members. But I just wanted to make sure, just to cover all angles if we need it. If we don't need to, I'm fine with not adding it. I just wanted to make sure.
I don't feel comfortable adding that in. I mean, I'd like to, but as a board, I don't feel like we have the right to dictate to the contractor or the homeowner. Hopefully they have taken our suggestions to heart and will do the right thing, but I don't think I would like to put anything in there about this.
I would agree. And as Mr. Floyd said earlier, it's in the homeowner's best interest for that not to flood. That's their side yard of their property.
Okay.
So I would rather not.
Yeah, I feel the same way too. I just wanted to make sure that we didn't need to put any language in there proceeding. I'm going with that. Okay, great.
All right, then. Dryden, I make a motion for the finding of facts and conclusions of law be accepted as written.
Okay, there's been a motion moved by Mrs. Dryden to accept the finding, facts, and conclusion of law as stated. Is there a second?
Long, second.
Okay, motion's been moved by Ms. Long. Now go to voting. Ms. Long?
Long, yes.
And Ms. Dryden?
Dryden, yes.
Mr. Floyd?
Floyd, yes.
Wilson, yes. Okay, that concludes that case. Terry, the next case, and I don't have my agenda in front of me, is that on the regular agenda? Are we moving to the regular agenda now?
That is correct.
Okay, and is this
100.
And is this our last case of the day?
Yes, Chair.
Okay, all right, great. So let's proceed to that case then.
Did have opposition signed up, but they're not currently here. But it looks like Vincent Desperoso is in attendance as the applicant.
Okay. Okay, great. I'm just trying to pull it up on my end too. So our next case is 2021-100. And since the applicant is not, since the opposition is not here, I just want to ask the applicant. And I don't know if you said Mr. D. Prospero is on? Okay, there you go. I see you. And forgive me if I mispronounce your last name. Just wanted to ask, are you okay with the board moving with your case today with 4 members instead of 5?
Yes.
All right, thank you.
All right, the next case is a proposed right-of-way variance request. The applicant is requesting a variance from the 175-foot proposed right-of-way and transitional setback required for lots abutting a freeway to develop a vacant lot. And I'll give you a minute to look at your findings.
I'm sorry, did we get confirmation from the person opposing this that they're okay moving forward with 4?
They're not in
They're
attendance.
not on the call.
Oh, okay.
Terry, can you let my partner in, David Matucci, and let him speak for us, please?
And you will have a chance to speak as well as your partner at the end of the presentation. That was where both of you went at that time.
Very good, thank you.
Okay. Okay, Lisa, you may proceed.
All right, Exhibit 1 is a vicinity map of the subject property. Exhibit 2 is a zoning map. The property is zoned R17 MF, which is a multifamily zoning. Exhibit number 3 is an aerial map of the property. And you can see the location from Brookshire and I-85. Exhibit number 4 is a close-up aerial of the property. The property is currently vacant. Exhibit number 5 is background of the property. The property is located along Brookshire Boulevard, and that has an existing right-of-way of 45 feet measured from the street center line. Since Brookshire Boulevard is classified as a Class 1 freeway, there is a 175-foot proposed right-of-way required per code that's measured from the street center line. So you can see that back towards the rear of the property where that would fall measured from street center line. The setback of 30 feet is measured from the proposed right-of-way. So you can see that falls about 38 feet from the rear of the property. And this is called the transitional setback since it's measured from the proposed right-of-way. The required rear yard is 40 feet. So the transitional setback and rear yard overlap, giving no permitted building depth on the property. Slide 6 is the variance request. The applicant wants to construct a planned multifamily development and associated parking and improvements on the property, and they're requesting a variance to waive the transitional right-of-way and utilize the existing variable 45-foot right-of-way and 30-foot setback from the existing right-of-way. Staff did not find this request to meet the criteria for granting a variance in the zoning ordinance. So instead, staff supports a modified variance, and the applicant has agreed to this modified variance and submitted this revised plan. The modified variance is for 125 feet from the 175-foot proposed right-of-way to permit a proposed right-of-way measured 50 feet from the center line of Brookshire Boulevard. The 30-foot setback would then be measured from the 50-foot right-of-way. Exhibit 8 is considerations. Staff supports the approval of the modified variance. The North Carolina Department of Transportation indicated it's unlikely that NC 16 will be widened or that any additional right-of-way in the area around this development will be needed for roadway. They said that additional right-of-way may be needed for pedestrian accommodations. The modified variance request would result in 5 additional feet of right-of-way width, or 50 feet measured from center line, which is consistent with the proposed right-of-way required for major arterial Class 3 thoroughfares and allows for possible future pedestrian accommodations. The hardship is not a result of actions taken by the applicant and results from conditions peculiar to the property. The depth of the property is approximately 198 feet, and when the required 175-foot proposed right-of-way, 30-foot transitional setback, and 40-foot rear yard are imposed on the property, there's a 2-foot overlap and no permitted building depth. Granting the variance will not adversely affect adjacent or contiguous properties or change the character of the area, because there are other encroachments into the proposed right-of-way along Brookshire Boulevard. And you can see that in the image on the right side of the screen. Granting the variance will secure public safety because of the additional 5 feet of right-of-way for possible future pedestrian accommodations. Exhibit 9 is photos of the property. And that's the end of my presentation. Let me know if you have any questions for me.
Thank you, Lisa. Does the board have any questions for Lisa?
Yeah, Lisa, I just want to be clear, that 175-foot proposed right-of-way, that's a requirement under the ordinance. There's not any kind of NCDOT requirement or anything?
No, that's just the zoning ordinance requirement.
And so what happens if I guess NCDOT would just come in and condemn if something's constructed there?
Correct. And the applicant provided some communication that they had had with NCDOT, and they said that they didn't believe that they'd need additional right-of-way for the roadway, but it's possible that they could need additional width for pedestrian accommodations.
Okay.
Lisa was,
Yeah, go
was
on,
this at
go on,
one
Ms.
time am I on? Lisa, was this a single family home at one time? Is that a driveway that's up there?
I believe the last use was a single family home because that's the use listed on GIS.
Okay, thank you.
Any other questions for Lisa? Okay. Does the applicant have any questions for Lisa based upon her presentation?
No, not at this time. We just thank you for your time and looking at this for us. Thank you.
Okay. And do you and your partner, do you have presentation to give? Anything like that? Just want to make sure that I ask.
No, we've went back and forth with the city and NCDOT and have our proposed plan and just hoping it gets approved.
Okay, great.
No,
Okay.
the driveway that she was referencing a minute ago, that's actually a construction entrance that we put in with the anticipation of when we had to clear the site.
Okay. All right, great. I was
Lisa, I'm sorry.
trying to stop you in case I would have to swear you in if you kept presenting, but I just wanted to make sure.
Lisa, can you go back to the slide that shows the layout? Thank you.
So where's the entrance for this going to be? Off of what road?
They're showing 2 entrances off of Brookshire and the other one on the side street, and I believe that's Nelson Street.
And DOT's okay with the entrance off Brookshire Freeway?
They haven't reviewed this, so this would just be for the variance request for the transitional right-of-way, and then it'll have to go through planned multifamily development review.
Okay.
So they've answered the question about the transitional right-of-way itself, but they haven't looked to the level of driveway locations and things.
Okay.
And if the board members, if you have any questions for the applicants, let me know. If so, I just want to make sure that I swear them in case they have to start going back to the exhibit. So if you have any questions, let me know.
Well, I do have a question.
Okay.
Part of for them.
Mr. Ryden, before you ask, let me just go ahead and swear them in, just be on the safe side in case they have to pull back up exhibits.
Okay.
So Mr. Vinny D. Prosperio and Dave Mateucci, if you can both state your, I know I stated your name, but I probably messed it up. My apologies. If you can both state your full name and address.
Sure. This is Vincent D. Prospero, 5430 Stalwart Drive, Charlotte, North Carolina, 28226.
Okay.
Dave Matucci, 566 Hamlin Parma Town Line Road, Hilton, New York, 14468.
Okay, great. Do you both swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Okay.
Yes, I do.
Okay. Great. Okay, Mr. Ryder, you can go ahead and ask your
All
question.
right, I just want to clarify, with this revised, this modified plan that you've submitted, I see that you have, you've gone from 18 units down to 16 units. So that was part of the reconfiguration to get this down. You've eliminated 2 of the condominiums or townhomes or whatever you're building.
Yes, at this point, after trying to fit it inside the box, yes, we eliminated 2 units.
Okay, that was my question. Thank you.
Do any other board members have questions for the applicants or for Lisa?
Lisa, who did you say looks at this after, if we approve this variance, who has to look at this?
It would be reviewed by the land development group.
Okay, thank you.
Does the board have any other questions for Lisa or the applicants? Okay. Hearing none at this time, this will conclude the presentation of evidence. The board will now begin its deliberations. Just a reminder to the applicant and the other parties that you are not permitted to address the board during this portion of the meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. So now the board is in deliberation. This time, the board member I see first on my screen is Mrs. Dryden. So I'll start with you.
Okay, thank you. I like that they modified the plan to allow for the 125-foot variance rather than the 175. And that DOT has signed off that they're probably not going to widen the road. So I would, with the modifications, I'm inclined to approve this.
Okay, great. Mr. Floyd?
Yeah, I agree with Ms. Dryden. I think it meets the criteria for granting a variance, and so I'm inclined to approve.
Great. Ms. Long?
I also agree with the modified variance.
Great. And as the chair, I feel the same way as well. I agree with the rest of the board members too. Okay. So that concludes our deliberations. Now, when we move into voting, I believe there's 2 things we have to do. And correct me if I'm wrong, our city attorneys. Is 1, we have to make a motion to deny the variance requested first, and then approve, and then make another motion to approve the modified variance. Am I correct? Or can we just? Or can we just go ahead and just approve the modified variance?
I think it depends on, ask staff is what was, I thought what was presented was the modified variance.
I believe it was, and in the application, we have first the denial, and then we have the staff recommends approval. Okay, well, I guess you're right. Then, yeah. So
This is Jill. Can y'all hear me now?
Yes, Joe, we can hear you now.
So, you know, I think procedurally, the applicant has sort of, in effect, withdrawn their original request and, you know, today presented a modified variance request. So I don't see an issue with just voting on the variance as requested today, as modified and presented and unopposed by staff. But anyone let me know if you disagree.
No, I think that's the way to go. I just wanted to make sure, just based upon the documentation I have in front of me, if we needed to, you know, go the route I presented before. So, okay. With that said, is there a motion to approve the modified variance? And I don't believe I have to read it out, but is there a motion to approve the modified variance?
I make Long makes a motion to approve the modified variance.
Okay, motion's been moved to approve the modified variance by Ms. Long. Is there a second?
Dryden.
Second by John Floyd.
Floyd. Go with
Okay,
Floyd.
there's a second by Mr. Floyd. Now we move into a period of voting. Mr. Floyd?
Floyd, yes.
Okay, Ms. Long?
Long, yes.
Ms. Dryden?
Dryden, yes.
Okay, Wilson, yes. Okay. Now we're going to now we're going to the finding facts and conclusions of law of the modified variance on your on the application here.
I
Is there a
make a
motion to-
motion. Yeah. All right, go ahead,
Okay.
Mr. Floyd.
No, that wasn't me. I was saying
Oh.
that there is a motion. Yeah.
Yeah, I want to make a motion to accept the finding of facts and conclusions of law to the modified variance.
Long second.
All right. There's a motion was moved to accept the modified facts and conclusions of law for the modified variance. And there was a second by Ms. Long. And now we move into a period of voting. Ms. Long?
Long, yes.
Okay. Ms. Dryden?
Dryden, yes.
Okay. Mr. Floyd?
Floyd, yes.
Okay. Wilson, yes. Okay, that concludes that case of the day. The next on the agenda, Terry, I believe, is just the minutes from the last meeting.
That is correct. August and September.
Okay. Board members, I would assume you had a chance to review those. And is there a motion to approve the minutes of August and September?
Long makes a motion to approve both August and September meeting minutes.
Okay.
Second.
All right. Motion was made to approve the August and September minutes by Ms. Long, a second by Mr. Floyd. Now I move to a roll call vote. Mr. Floyd?
Floyd, yes.
Ms. Long?
Long, yes.
Ms. Dryden?
Does it make a difference that I wasn't here in September? I mean, I
Nope.
vote to approve them, but I wasn't at the meeting in September.
I don't think it does.
Okay, then I vote yes.
Okay. Wilson, yes. Okay, I think that concludes the agenda for today. Am I right, Terry?
There's one other item we need to discuss is
Okay.
what I kind of mentioned earlier is that effective last week, the government center is open for public hearings and for folks who come to the public hearings, and that would include quasi-judicial boards, which y'all are a quasi-judicial board. And then effective November 1st, the building is open to the public on a daily basis. So what we're asking y'all is, and this is something the manager's office has asked, is I think they, at this point, are wanting to get back to in-person hearings, if that's possible. So right now, we're under that statute that says, during a state of emergency, that a virtual hearing is an option. So it still is an option because my understanding is we're still under the technical state of emergency for the pandemic. But if we can get 5 members to say, yes, we will come next month for hearings, then all those requirements that we currently have in place for requiring the applicant, anyone withstanding to consent to the virtual hearing, we won't be doing that anymore. And because we'll be in person. So I guess the question, how many of y'all are comfortable coming into the government center starting next month, which will be November 30th, which is the last Tuesday of the month, to have the hearing? I mean, maybe you don't tell us now, maybe you don't want to do it in public, but we do need to know very soon so we know how to plan ahead, because like I mentioned earlier, there are several cases, and maybe Lisa will have to help me how many, the number, but we have we need to start scheduling those if we are going to have in-person hearings, because they did not consent until we have in-person hearings again. So we just need to know how to schedule our upcoming cases. And it
Chad,
depends
I guess
on this.
one question I've got is, what does an in-person hearing now look the same as it used to, where that room that you're in, we're all lined up around the table and we've got everybody in the room with us all at one time?
What we can try to do is get room 267. We'll have to see what the availability is. And I don't know if any of y'all are familiar what 267 looks like, but that's the larger room. This is our typical room that we're in. But if y'all agree to come back, we'll try to get room 267 for the hearing, which is we can spread out more. It's a lot bigger.
I was in 267. I came, a couple of months ago when they first, they opened it and then they closed it. But I came downtown, and that room is sufficiently large for everybody to be separated by at least 1 seat or 2 for the 5 of us to be in that room. And I'm willing to come back in person whenever you're ready to have us. I much prefer that.
And Shad, if you can make the room look like Miss Dryden's background, I think everybody will be able to come back.
I'll work on that.
So, I mean, does the board feel comfortable giving Shad an answer now, or do you want to do it through email? I don't want to, like Shad said, make anybody feel uncomfortable, like they have to say yes now. And I know that's a couple of days after Thanksgiving too. So, I think we should be able to meet, because I know the last Tuesday in December is going to.
Well, I do want to talk about December, because historically we do that a little earlier.
December 14th is what's scheduled.
Yeah, around the 14th, as opposed to after. So I don't have a problem with the 30th, and I will come in person, and I would like us to meet on maybe December the 14th, as opposed to the 28th.
Yeah, our calendar already has us down for December 14th.
Okay.
Regular meeting.
All right. Well, I'm on board to come back.
I have no issue either.
Okay.
Yeah, neither do I. December 14th, I may be out of town, but I'll let you guys know. I'll have to double check.
Okay.
Yeah, and I'll just let you guys know, I am scheduled to be in trial beginning the Monday after Thanksgiving. I suspect that's going to get pushed given what's going on in the Mecklenburg County Courthouse, but I don't know for sure. So I would say for now, you probably should count on getting 5 without me.
So do we have 5 without him? I mean, we have some vacancies.
Yeah,
right?
You do.
We still have Mr. Ragu and Marshall, right?
Yeah.
Yes.
Yeah.
We have
My term is up at the end of January, so y'all better fill some spots.
You're not gonna come back?
We'll see. Am I allowed back? Who knows?
Yeah.
Yeah. We need you back, man.
How many vacancies do we have?
2. And we had one of the 2 filled, but the person who was appointed decided that they did not want to be on the board.
Oh, did they not like us?
I don't know.
Maybe don't like Tuesdays.
Well, yeah, maybe that's true.
Yeah. All right, so we will go ahead and we'll reach, well, all right, so what I'm hearing is everybody here, well, other than Mr. Floyd, November 30th kind of works. We'll have to reach out to Raghu and Marshall and then get their thoughts. And once we hear back from them, we will go ahead and plan on an in-person hearing if they're good with it in November. And so we'll probably have our regular, well, the one that was continued today, and we will have whatever comes in. But we'll go back and start looking at the cases that are backlogged. We can't do all of them. So we'll just have to kind of take them and just kind of figure out timing, because I know y'all don't, today was a long meeting. You probably want a lot of days like this, but
Well, and Shad, is one of those cases the one like with Ballantyne that Scott Tyler is the counsel for one of the parties, and
that's done. That's gone away.
That okay. I was gonna say because I got a conflict with that one.
Yeah, yeah. That one is done. We don't have to worry about that one. Thank goodness. Yeah.
The one that ended up in federal court.
Yes.
Yeah.
Oh, Jesus Christ! I'm glad we don't deal with that.
Yeah.
Okay.
Are we still being recorded?
Well, no.
Okay. Yeah, I know I've been speaking out of order, so sorry about that.
Oh yeah, we're still live. We're not on court reporter, but.
Okay. Yeah, she put her. Well, I just want to thank the staff. Thank you guys for this long day. I don't think you guys had a chance to eat lunch. I don't think anybody. All I had was 2 waffles and coffee before I got on. And of course, board members, thank you too for hanging in there. I think it's the longest I've been on, been in meetings since I've been in the zoning board, and I know that appeal was long. I learned a lot on what not to do next time. I'm going to have to try to, do some baseball umpire moves just to make sure that we can move along through that. So, yeah.
Can I thank you, Douglas? Can I just to go back to the in-person meeting, and Shad and Terry, maybe you can give, because I know that Mr. Raghu and Mr. Is it Marshall? I don't know if that's his last name. First name is not on, and they will need to be contacted because with the quasi judicial hearings, it's very important that the staff rather know by a certain time period, and so that they can notice the hearing properly and get the proper consent if it's not going to be in person from the parties who have standing. And so, as Shad said, we still are under a declaration of emergency from the governor. So remote meetings are an option, but the building is open as of next month, and we can hold the in-person meetings. It's just really important that we get everybody to state their availability in advance, because if one person can't be there and wants to be virtual, then that converts the entire meeting to a remote meeting, and then different rules apply. So, I think hopefully Shad and Terry can, email you guys the, drop dead date for knowing what your availability is on the 30th and whether you can attend in person or would prefer to be remote.
Definitely. Okay. Thanks for bringing it up. So yeah, I guess Terry and Shad may just want to try to email Marshall and Raghu maybe before the day is out, so we can get them on record on what they would like to do next month.
All right, we will do it.
All right.
Before we leave, Terry, can I ask you please I read the minutes online, but I've lost them and I didn't print them before. Could you send me another copy of them, please?
Yes, ma'am.
Minutes from August. Thank you. Appreciate it. Oh, and y'all tell me what happened to Max. I mean, I guess he's gone. I know. I see Terry there. Did,
He moved to a different team in our group. So he's
oh,
we talked about that multifamily project's going to have to go through land development review. He's now
Right.
in the land development review team. So
oh, cool. Okay.
that's where he is.
Yeah, because Max and I came on at the same time. He was brand new when I came on brand new, so we learned together.
He's still here
Well,
with the
thank you.
city, just different role.
Okay, cool. Well, welcome, Terry.
Thank you.
All right, thank y'all. I've got a 3:00 appointment, so I'm going to
Yeah.
say adieu.
Thanks,
All right.
everybody. See y'all.
Thank
See
you.
ya.
See y'all.
All right, so
No,
motion
Thanks,
to
everyone.
adjourn. We adjourn.
All right.
All right,
Thanks,
thanks a
everyone.
lot.
Yeah.